Maybe the lordship. Also, one bail matter lordship, it was fixed today lordship, and as well today lordship, mandatory basis of over lordship. It was fixed lordship, but it happened listed lordship. Lordship, maybe take up today itself lordship, because mandatory basis are already over lordship.
I don't know. Today lots of matters are there. Maybe tomorrow. Tomorrow.
I beg to mention for listing on Friday, next Friday.
What kind of matter?
Matter relating to special act, bail matter.
Friday.
Friday.
Friday. How many matters a team is to know? She's
Came
not here
in
today.
Last four matter.
No. Fixed matters are there. That's what I'm saying.
Not-
Already there.
Is behind the bar since long day.
No, whatever. What is the date on next Friday?
9/5.
Oh, 9 to not possible. 9 not at all possible.
Before that.
9 date not at all possible. Because we are requesting rather the registry to fix list numbers of matters because of all these matters. So maybe by 10, 11, 12 is holiday, na?
Any day.
Okay, then 14th, 13th or 13th.
In item number 24, we have filed an additional affidavit for bringing some documents. Kindly that may be called for.
24. Hmm. 24 at affidavit. Okay.
May I please your lordship, I beg to mention for listing one bail application lordship. 13 lordship. Much obliged.
May I please, lordship, I beg to mention item 29, lordship. The
20.
English council is out of station, so kindly adjourn this matter.
Just a second. 29.
Yes, sir.
It's a AB matter. Whether here we have received any case. CD not received. Are you on interim?
Yes, lordship.
You are in interim. CD not received. Received, not received. Oh, charge sheet submitted. Okay, then.
Indeed, lordship. The
No,
English,
charge sheet submitted.
lordship, English council is not.
Oh, acha, you are not in a position to say. Okay, then any date will be maybe by Thursday. Okay, Thursday on 8. Yes.
Lordship, after 1 week, lordship, he is went to his native village for election.
No, it
purpose.
is a charge sheeted case. What to do then? Otherwise, you lose dating.
On 10, lordship.
10, 11, 12 are holidays.
Oh, 13,
Okay, 13.
oblige.
13 she করে দিব CD interim be extended till next chapter. Add a request করে দিব.
I beg to mention item number 16, lordship.
16.
16. Lordship, the NDPS council has some personal difficulties on today, lordship. I am not on record, lordship. Mr. M. Sokia is there. He has some personal difficulties.
M. Sokia.
Lordship.
It will go after 19, 20, 21, I think, na? Or after 2 weeks.
Lord.
Oh.
Obliged.
Add a request made by so and so list after 2 weeks.
Obliged.
May I please, your lordship? Lordship, I beg to mention on bail application. This is for motion, lordship. On the last occasion, lordship was pleased to fix this matter on 7th. 7th now it has been declared as.
So what to do? 7 lots of cases are there. Not only your case, na?
On
Lots
9th,
of matters
lordship.
were there.
On 9th.
No, not at all. Maybe on 14th. At best.
Lordship, I beg to mention item number 40, my lord, 40, my lord.
40.
This is okay. May kindly be awaited, my lord, in this case, my lord.
40 service is still awaited.
My lord, my lord.
Go for the petitioner.
My lord.
SD name has been reflected here in the pause list for the respondent.
But wrongly it was listed, perhaps, but the SD was for the petitioner, but wrongly it was listed. It was.
Oh. So your name is reflected here in the cause list says
W. Rahman.
W. Rahman. And SD is also for the petitioner.
For the petitioner, but wrongly it was put, my lord.
Oh, acha. So
for the-
service is still awaited.
Is yeah.
Har Mr. W. Rahman, Dilani 40. Har Mr. W. Rahman, Dilani counsel for the petitioner. And it is submitted. The service is still awaited for the respondent number 2. Let the service be awaited till next date of listing. List accordingly after 2 weeks.
Fine.
List after 2 weeks.
May I please, your lordship? Well, I wish to mention for listing one bail application, my lord. It was fixed on 7, but 7
Oh,
was.
that same citation is Mr. Ahmed also submitted me. Maybe in 14th. Not before that.
Daily list. Bail motion, item 3.
Your Lordship.
Yes.
Lordship, this is the charge sheet and matter, Lordship. 5 witnesses have been examined in this case, Lordship.
5 witnesses already examined.
Already examined, Lordship. What has happened, Lordship? Lordship, the FIR is on page 10, Lordship.
What, is the NDPS or?
NDPS, Lordship.
Okay.
This is a NDPS case, Lordship. Lordship,
It's a intermediate quantity. Oh, no, commercial.
commercial quantity. Problem is, Lordship, that the substance was found in a public place, Lordship, in a forest, Lordship. There is no conscious possession in this case. Lordship, the witnesses also retaliated the same thing, Lordship. One problem is that, Lordship, we have annexed section 50, Lordship, notice, which, Lordship, they have not been given the grounds of arrest, which is on annexure 5, page 33.
33.
Yes, Lordship. Both the accused, Lordship, they have just been merely given the case number and the sections. From page 33, annexure 5.
Mr. Chief Judicial Mr. Focus. Okay. Yes, 50 and 51. You have obtained the certified copy also?
Yes, Lordship. These are certificate copies only.
Photo certified.
Yes, Lordship.
Your petitioner's name is?
There are 2 petitioners, Lordship. and Rajilto.
One
Nazari.
is Porobi.
Yes,
and Dubori.
Dorobi and Rajilto.
Durobi, who is Durobi?
Dorobi is the first one, Lordship, who was arrested, Lordship. The seizure was made in
So
the
for both
absence.
the petitioners, you have annexed these copies?
Yes, Lordship. Both the petitioners. First one is Lordship Dorobi, and the second one, Lordship, is on page 35. That is Rajilto.
So since when they are in custody?
Since 28/6, one is, Lordship, since 28/6/2024, and the second one is from 30/6/2024. More than 300 plus days. Lord.
Recovery was made from his house.
Not from his house, Lordship.
House.
But as
Not
per
from his
the,
house.
as per the,
Lordship,
there was a total of 104,380 kg of suspected ganja was seized and brought to the police station.
Lordship,
Where from it was recovered?
He
Lordship.
conducted a search at the residence of one Dorobi Nazari Sakal at Jordanpur. After obtaining proper permission from the additional time during the search, a total 104.38 kg of suspected ganja was seized from and brought to the police station. His house, from his house.
Lordship may come to the evidence, Lordship, deposition. Lordship may clearly see, Lordship, the page 26, Lordship, annexure 4, Lordship, cross, Lordship, of independent witness, and there are police witnesses also. Lordship, in the cross, I did not see the accused person at that place. The jungle is at a distance of about 100 to 150 meters from the house of the accused Dorobi Nazari. There were houses of people nearby the said place. I saw the ganja packets at a public place. My house is at a distance. So, Lordship, these packets were recovered from a jungle, Lordship, not from his house. Same thing has been retaliated by PW2 also, Lordship. In their absence, Lordship, the recovery was made. Jungle is at a distance of 1.5 kilometers from the house of the accused Dorobi Nazari. PW2 also states the same thing, Lordship. Then, Lordship, third one also PW3. I was not present at the time of recovery of the plastic bags. He directly states that he was not present only. Then there is police constable, Lordship, the police personnel. The packets were recovered at the back side of a house of accused Dorobi. There was no fencing at that place. There was jungle at that place. Other people can go to that place. We went to the house of accused Dorobi Nazari, but found no one present at home. Today I have not seen this thing, Lordship. Then PW5 also states the same thing. The packets were recovered from under bamboo grove. The bamboo grove is at a distance of 100 meters from the house of accused Dorobin.
The backside of his house.
Conscious possession has not been proved. In their absence, seizure was made. That is also in a place which is not their home also, in their premises. Lordship.
As per refer Mr. Kusami is your conscious possession from the house.
From the house, maybe his residence.
Apart from this, you have taken the grounds of this.
Yes, Lordship. Apart from this, Lordship, grounds have not been furnished to them. Lordship, I think Vihan Kumar has clearly stated the.
And we will actually বাকি খানি টাকা মারি দিব। Heard Mr. P.K. Das, the learned counsel for the petition, and also heard Mr. D.P. Kusami, the learned additional PP, appearing on behalf of state respondent. This is an application in section so and so in connection with so and so. It is submitted by Mr. Das that the accused petitioners are behind the bar since petition number 1 and 2 are behind the bar since last 28/6/2024 and 30/6/2024 respectively. But it is submitted that the recovery was not from the conscious possession of the accused petitioners and from the evidence from the statement made by the witnesses. It is also seen that the recovery was made from a jungle, which is not the house of the none of the accused persons. Further, he submitted that five witnesses have already been examined by the prosecution, and the accused persons being the permanent resident of their address locality will appear and contest the case. Will contest the case by appearing before the learned special judge on each and every date to be fixed by the court. Mr. Das further submitted that at the time of issuing notice under section 50/50A CRPC, there was no mention of ground of arrest and except the case numbers and so and so. Baki hin likhi diba. Vihan Kumar Sumar and the next para, Mr. Goswami, the learned additional PP, submitted in this regard that the recovery was made from the conscious possession of the accused petitions and it was recovered from the house of accused Durobi Narzari from his backside of his house of Durobi Narzari, which can be considered as a conscious possession of the so and so. Mr. Goswami further submitted that 5 witnesses have already been examined by the prosecution. Out of how many witnesses are there?
13 witnesses.
13 witnesses, and thus the case is going in a good pace. And within reasonable period, the completion of the trial can be expected. Furtherly, baki his submission academy, please. In whose satisfaction this one?
Lordship,
Pending before which court?
Special Judge Pokraja, Lordship.
To the satisfaction of the special judge. Baki hil mai diba. Okay.
Lordship.
Is disposed of. কোন নাম বলছি আছে কই দিছে অ্যানাউন্স করে দিছে আপনি কই দিছে
The matters listed under delivery of order will be called up at 2 p.m. Item 4.
So here also I have taken the same ground lordship violation of article 21 and 22 lordship. Can you see lordship that is number 18 lordship?
80
No, 18 lordship.
18.
Yes, sir.
Yes.
The
One
arrest memo.
Hmm.
And next, the document, there is nothing about the ground of arrest.
Then on other documents.
Lordship pays next case. Lordship.
It's a notice.
Yes, sir. There is also nothing.
Then where it is the 47, I think. Then
Yes,
48,
yes.
48, where is the 40?
48 was not served.
Conscious person. Pardon? Your petitioner is in custody since 3101.
Lordship? Yes.
3101 2025.
25.
Not is charge sheeted.
No.
Can you raise the issue of your conscious position as per FIR? I won't say otherwise. As per FIR, what is your conscious position?
Yes, Lordship.
As per
As
FIR.
per FIR, Lordship, from personal body search, Lordship. Lordship.
That is a very strong then, otherwise also.
Lordship.
Rather more stronger.
Yes, Lordship. Otherwise, the coordinate bench already decided this issue, Lordship. I have the order, Lordship. Already.
Yes, heard Mr. Ajit Ahmed, the learned counsel for the petition. And also heard Mr. D.P. Goswami, the learned additional PP appearing on behalf of state respondent. But this is an application under section so and so in connection with so and so. It is submitted by Mr. Ahmed, the learned counsel for the petition, that accused petition is in custody since 31/1/2025. And case is not yet charge sheeted till date. It further submitted that there was no conscious position from the conscious position of the there was no recovery from the conscious position of the accused petitioner, and he is no way connected in the arrest offense. Further, he submitted that accused there was no grounds of arrest were mentioned at the time of issuing notice to the petitioner, as well as while issuing on the arrest memo. Further, he submitted that the family members were also not served with any notice under section 48 of BNSS, intimating the ground of arrest of the present petition. He further submitted that the accused is from which state?
Lordship?
Your petitioner is from which district? South Salmara. He is a permanent resident of his address locality and will appear before the learned trial court below on each and every date to be fixed by the court after, if the case ends with charge sheet. Next paragraph. Baki hitar I will give you. You take just a second. You have to take one. This order is there which Lipak, one order is there regarding the conscious position. So that has to be implemented. I'll show you afterwards. And next paragraph, Mr. Goswami further submitted in this regard that the contraband was recovered from the conscious position of the accused petitioner, wherein used quantity of Yaba tablets were recovered. Yaba tablets were recovered from his personal body search, and the present petitioner is very much involved in the arrest offense. Mr. Goswami further submitted that the case is still at the stage of investigation, and considering the nature of offense, the bail should not be granted at this stage. Mr. Goswami further submitted that the case is under the commercial quantity, and hence the rigor of section 37 will also follow, which speaks really baki Hindi. I'll show you. Okay, I'll pass the order. We have not conscious position. We have not delivered the order. It will be the order will be at 2 p.m. Will be passed. See whatever the order will be there.
Item 5.
Lordship, 5 also my matter.
Same.
Lordship.
Same out of same affair?
No, Lordship.
No.
Another, Lordship. Here, the petitioner is behind the bar, Lordship, since 24/8, Lordship, since 13/8/2024. For the 8 months, 18 days, Lordship, this charge-sheeted case, Lordship. Out of 11 witnesses, Lordship, no witness has been examined, Lordship. And here also I have
11
taken,
numbers of witness.
yes, Lordship. Here I have also taken the same ground, Lordship.
You have annexed the,
Yes, I have also taken.
where is the page?
Yes, Lordship, page 34 is the arrest memo, Lordship. Last two pages, Lordship, 34 and 37.
This is under 60 BNSS.
Yes, Lordship. Apart from that, 60, Lordship, at the time of while the Lordship 60 is compliant, there is corresponding to 47, that should be also compliant. But this is not
Do you
compliant,
have,
but
do you have now? With the certificate copy, do you have?
yes, that certificate.
No. 60 is already. Otherwise, 47, 48, do you have?
No, Lordship, 48, 47 is not at all sub, Lordship. that
Then we
time
call
is
for the
touching
case
it.
record.
Yes, Lordship. And give a short date in this case, otherwise,
We
Lordship.
don't have any shortcut otherwise. Scan copy of the case record along with the CTB call for. At best, we can give you either 2021, not that.
Lordship.
At best 2021, do we go
16.
16, sorry, 16, now there are some matters for hearing, in fact.
19.
19, okay, then 19 we're giving, 19.
Item 6.
Yes, Lordship, this is also my matter.
19 fine.
Yes.
Yes, this is also yours petition.
Yes. Yes, Lordship. Here, Lordship, the petitioner is behind the bar last 1 year, 2 months, Lordship. This are sheeted case.
1 year, 2 months.
Yes, Lordship. There I have annexed the 47 and
How many witnesses are listed?
yes. Lordship. There, 8 witnesses. Lordship.
Listed 8 witnesses.
Yes.
Is there any witnesses
No, no.
examining?
No.
Till now, no examination.
Arrested on 24/2/2024.
So here, you take the same plea of,
Yes, yes.
where is your Perry?
22 and 23, Lordship.
22 and 23.
Yes, Lordship.
Here he is a habitual offender. Earlier, he was arrested in another NDPS case.
Oh, wow. Previous conduct is there.
Maybe Lordship, only on the Lordship is violation of fundamental right, Lordship. 1 year, 2 months, Lordship.
Here, conscious position regarding what do you want to say? Conscious position. Heard Mr. E.J. David, the learned counsel for the petition. And also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Ahmed that the present accused petitioner is innocent and he is no way connected in the alleged offense. He got arrested in connection with this case on 24/2/2024, and since 1 year, 2 months,
2
he
months.
is in
12
custody.
days.
but prosecution could not examine any of the witnesses out of 8 numbers of listed witnesses. Mr. Ahmed further submitted that at the time of arrest also, the petitioner was not provided with any intimation regarding his arrest, neither in the arrest memo nor at the time in issuing notice under section 47 BNSS. Also, he submitted that these friends and family members were also not intimated the grounds of arrest, and notice under section 48 BNSS is also not issued for the family members. He further submitted this also you have to take from Lipak. I'll show you one where from the paragraphs you can edit. Next para, Mr. Goswami, the learned edition PP submitted in this regard that the recovery was made from the conscious possession of the accused petitioner, and a huge quantity of the contraband was recovered from him. Further, he submitted that case has already been charged sheeted. However, till date, the prosecution could not examine any witnesses. Full stop. Mr. Goswami further submitted that from the forwarding report itself, it is seen that there was a earlier criminal antecedents of the present petitioner, and he also got arrested in another similar kind of offense earlier. Mr. Goswami further submitted that cases of commercial quantity and river of so and so and so. Take a second. So this also you can take from Lipak. Okay, this one also will pass the order regarding the conscious possession.
And high levels.
And this is from district
South Salamanca.
South Salman.
Item 7.
Kindly see page 28, man. These are same, the notice under same counsel. Notice under section 47. No grounds, only section and the case number,
28.
28. Twenty-nine is the arrest memo. That is the inspection memo.
Case is not yet charged sheeted, I think.
Not yet charged. And in respect of the merit of the case, my lord, the contraband is recovered from an house of Hussein Ahmed, and Hussein Ahmed was not made an accused. Page 12 is the FIR.
Case 12.
Page 12, the last paragraph, my lord. On reaching the spot, may I read, ma'am? On reaching the spot at South Safasal, that is at the house of Hussein Ahmed, which is a newly constructed building situated at the Indo-Bangladesh border as shown by the source, and we saw that 4 persons were dealing drugs at the house of Baranda of Hussein. That Hussein Ahmed was not made an accused. And it is recovered from the house of Hussein Ahmed.
Yes, sir.
Hussein Ahmed, 2 persons, they are trying to claim. They were from the spot, 2 persons were arrested. From their position, it is recovered.
He was there in the Hussein Ali, in the house of Hussein Ali.
You know, Faizul Hussein, he was caught red-handed with that contraband.
Got red-handed.
Yes,
Oh, where
in
is
the Fija Lordship, on reaching the spot at Losil at the house of Hussein Ahmed, which is a newly constructed building situated near page number 19, Lordship, near the Indo-Bangladesh border, as shown by the source, and the saw that 4 persons were dealing drugs at the house Baranda of Hussein Ahmed, and I, along with my police party, the house premises, and on seeing of the arrival of the police party, the 4 persons were trying to run away from the spot. But we able to apprehend 2 persons, namely Zoinal Ahmed, so and number 2, Faizul Hussain. This petition, Lordship.
In this regard, my lord, my submission, my lord, kindly say page 4, para 6, my lord, in my pleadings. Page 4, para 6, my petition. Para 6. That the petitioner begs to state that he is a businessman by profession. He is not the owner of newly constructed house. On that day, petitioner visited the site construction to supply raw materials as per request of the owner of the house, along with co-accused Jainal Ahmed, as he supplies the bricks from the brick factory. On the day of the alleged occurrence, the co-accused persons was called by the owner of the house. The contraband was not recovered from the petitioner, not from the house of the petitioner. The contraband was recovered from the house of Hussain Ahmed, where one of the co-accused was sitting, but the police did not implicate the owner of the house in the FIR. Yes, sir, the petitioner cannot be called the possessor of the contraband. Then para 7, that the petitioner begs to that he was thoroughly interrogated during the investigation. There are no materials found against the petitioner that the petitioner is involved in the offence, and neither the petitioner is likely to abscond if granted bail by the honorable court. So, my lord, we are dealing the bricks and raw materials to the newly constructed house. That we are, my lord, dealing in fact, my lord. Something is there, my lord, we are visiting, my lord, but for which, my lord, we cannot be implicated in this offence. So apart from that ground, my lord, I'm taking the arrest procedure down, where clearly there is no ground is mentioned. And the original certified copies I have, my lord. May I place this one?
Yes, Goswami, otherwise from his purchase position. Heard Mr. H.R. Chaudhary, the learned counsel for the petition. And also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Chaudhary that the present accused petitioner is innocent and he is no way connected in the alleged offence. It is a fact that he was delivering some raw materials for construction of the building in the house of one Hussain Ahmed, wherefrom he along with one co-accused was arrested by police. The poison was not from the contraband was not recovered from his conscious position, rather it was recovered from the house of Said Hussain Ahmed, but surprisingly, police did not arrest the house owner or from whose house the contraband were recovered. Further, he submitted that the accused petitioner is the permanent resident of his address locality and he will appear before the learned trial court below. It is not charge sheeted one.
Not yet.
Even if the case is charge sheeted subsequently. Mr. Chaudhary further submitted that at the time of also raised the issue of non-furnishing of the grounds of arrest at the time of issuing notice under section 47 BNSS and arrest memo under section 36 BNSS, as well as in the inspection memo, the grounds of arrest were not mentioned while at the time of apprehending the present accused petitioner, which is mandatory required and baki hindi khiriba. Mr. Musami, the learned additional PP submitted in this regard that recovery was from the conscious position of the accused petitioner and he along with the other co-accused persons were there in the house of one Hussein Ahmed, where from they were dealing with the drugs. And accordingly, he was arrested by police. Mr. Goswami further submitted that case is still at the stage of investigation and accordingly raised objection and submitted that this is not at all a fit case wherein the accused petitioner can be granted bail at this stage. Mr. Chaudhary further submitted that this is a case of commercial quantity and the rigor of section 4037 will applicate. And from the plain reading of the FIR also, it is seen that there cannot be any reason to believe that the accused is innocent or will not commit such kind of offense if he is granted with bail, which is required under section 37 BNSS. বাকিখিনি আপনি লিখে দিব observation. In whose satisfaction this one is?
It's for a special just removing.
Special just removed. Okay, your matter will be disposed.
Nice.
তেখেতক লাগে যদি দি দিম তেখেতৰ certificate copy দি দিম disposed.
Item 8.
May I please your lordship?
Yes.
In this case, my lord, the same situation has arisen, my lord. I'm behind the bus for the last one year, 8 months, 4 days. And my lord, the issue is that, my lord, it's still in the appearance stage. Charges have been submitted, my lord. And
Why at this stage of appearance?
my lord,
Why at this stage of appearance till now?
and because my lord, the 2 persons or 3 persons are absconding accordingly, my lord, that is one, and they have filed it lately probably. And the other factor is that, my lord, that in the meantime, one of the co-accused who was arrested along with this accused person was released on bail by a coordinate bench, which your lordship will find it at page 47.
47.
Yes, madam. Taking into consideration the long interpretation, my lord, and certain judgments quoted at page 49, it starts from page 47, my lord. And of course, at that time, Bihan was not taken into. So now I am also taking that ground, my lord. So if your lordship will see 47, my lord, and submission starts from para 10, my lord, page 49. Para 8, I read, my lord. He has further submitted that the petitioner has been languishing behind the bus is more than 1 year and 6 months. Until date, even charges are yet to be framed. He therefore submits that the petitioner is entitled to get bail on the ground of prolonged incarceration. In support of his submission, the learned counsel for the petitioner has relied upon the following rulings, my lord. I have given 8 judgments. Then your lordship has come to a finding at page 16, 51, para 16. In case of Anupur Chaudhary versus State of Madhya Pradesh reported into her life, the Supreme Court of India has observed that the failure to conclude the trial within a reasonable time resulting in prolonged incarceration material against the precise fundamental rights granted under Article 21 and as such conditional liberty overriding the statutory embargo created under Section 37(1)(b) on M may in such circumstances be considered. So lastly, coming to para 20, my lord, page 52. So para 18 says, in case also the petition has been detained behind the bus for more than 1 year, 6 months, and charges are yet to be filed. In my case, it is 1 year, 8 months as on today, my lord. So under the facts and circumstances of the case, it is considered opinion this court of the long incursion of the petitioner has in the instant case outweighed the embargo of 37 NDPS, therefore he is entitled to get bail on the ground of infringement of his fundamental right guaranteed under Article 21 of the Constitution. And the grounds of arrest was also, as per the law, has not been punished to these accused persons.
Have you annexed those things?
That is what I could not find it, but I have given the complaint, in the final complaint, which is not stated there, my lord.
That is will be a bit difficult for us to take that.
Yes,
that
no,
note
no,
on.
in the complaint case, my lord, the Panchnama and all these are given, that they don't say anything as such, because they give every details, my lord. If your lordship will kindly see. Because notice was only given and accordingly my statements were recorded in the section 67.
That's what we want to see. In fact,
That
if
is
you can,
already
if you
there
can,
at page 22, my lord.
22.
2. Para 11. Shall I read, my lord?
No, I can see that you have taken that ground,
Yes,
but we need that at least certified copy or the photo certified copy, whatever. If you can furnish us by say next Thursday, we
my
can
lord,
make
I'll try, my lord, to procure it, my lord.
because apart
Yeah,
from
sir.
the long incarceration, you have also taken the ground of that non-furnishing.
Yes, my lord. Apart from this, my lord. That was not given to me, so I could not annex it, my lord.
Just within this week time, you can apply for the certified copy
Yes,
also,
ma'am.
that may be
I-
provided.
Any date on 8 or 9, my lord.
9 may not be possible, can it be? বহুত কেইটা ডেট আগতে ফিক্স হৈ আছে 9 of চাওকচোন।
Or they may also point it out, my lord.
Yes, they can also. But they do not have anything, I think, at present today.
Not have it.
At কিমান কেইটা ফিক্স হৈ আছে? আর 18 at present. Okay, then 9 we are giving.
My lord.
9.2 and the
My lord, notice may be issued and they may also produce the record.
yes, Heard Mr. Pinchak Kama, the learned senior advocate, assisted by
Here they are.
He
Parthod,
P. De Chaudhary, P. De Chaudhary, and also her Kakoti na here, and Kakoti, the counsel appearing on behalf of the standing counsel and CP. For the case record along with the case diary. In the meantime, the petitioner side may furnish the certified copy of the notices, as well as the respondent can file their written objection if any.
and they can produce the record, my lord. to
Yes,
check it.
record we have already.
Much of it.
I'm saying why I'm saying that you
Yeah.
have already taken that plea. Suppose in that case, in somehow if record we do
Yes,
not
maybe,
receive,
my lord.
in that case you can file your certified
Sure,
copy.
sure.
That's-
But otherwise also, my lord, I have made out the ground, my lord.
Okay,
We'll look
we'll see
into
it.
my lord. Much of it.
Item 9.
The lordship.
Yes.
In this case, on 15/3/2024, in the middle of the night, that is about 2 a.m., my lord, the police personnel stopped one auto vehicle, which was driven by one Setabuddin and occupied by one Raju Ahmed. From the driver's seat, my lord, they recovered 53 numbers of cough syrup bottle, my lord. And my lord, thereafter, my lord, during interrogation and investigation, it revealed that the present petitioner gave them, my lord. So it was basically on the confessional statement, my lord. He was arrested and he is behind the bar, my lord, for last 416 days. Lordship charge sheet has also been filed in this matter. And as per the my lord Eco's record, 22/5/25 is fixed for evidence, my lord. And my lord, so basically my plea, my lord, regarding the consideration of my liberty, my lord, is based on Annexure 5, which is at page 43, my lord. It was recovered, my lord, FIR is very specific, my lord, that it was recovered beneath the driver's seat. I was not the occupant of that vehicle, my lord. It is also there in the FIR, my lord. And I obtained the certified copies of these documents, my lord, for lordship perusal.
Now 43, you have annexed section 50.
Yes, my lord. Yes, I have annexed, my lord, all the documents which have been furnished to me, and I have also obtained the certified copies. May I just hand over, my lord, these documents?
The petitioner's name is down.
Diauddin, my lord. Diauddin. So, given by one Setabuddin, my lord, and it was another person was there in the auto, my lord, Raju Ahmed. Raju. Petitioner was not there, my lord. Only it is during interrogation and inquiry, it has been gathered, my lord, as per the prosecution, that this person, my lord, gave this contraband for some wrongful use. So that was the basic allegation made against this present petition. So my humble prayer before this lordship to kindly consider my conditional liberty, my lord. I am local person. I will face the trial, my lord, with any stringent condition, my lord.
Yes, Mr.
Recovery is not from him, other than Rajuddin and Setabuddin. As per their statement, they were instructed by him. So this petitioner. So, tell the rest.
Certificate delivered. Certificate can be delivered. And Mr. M. A. Chaudhary, the learned counsel for the petition. And also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of suit respondent. It is an application under section so and so in connection with so and so. It is submitted by Mr. Chaudhary that the present accused petitioner is innocent and he is no way connected in the alleged offence. Recovery was made from a auto rickshaw, and on the basis of the statement of the co-accused only, the present petitioner was arrested on 15/3/2024. CS has already been submitted and case is fixed for evidence on 22/5/2025. The accused petitioner being the permanent resident of his address locality, he will appear regularly before the learned special judge as and when the date to be fixed by the court. Mr. Chaudhary for next para, Mr. Chaudhary further submitted that no grounds of arrest were mentioned while issuing the notice under section 50 CRPC as well as in the arrest memo and the inspections memo, which is mandatory required and non-furnishing so and so for you. Takes. Next para, Mr. Goswami, the learned additional PP submitted in this regard that it is a fact that there was no conscious recovery from the conscious portion of the accused petitioner, but during investigation, it has come to the notice that the accused petitioner is very much involved in the alleged offence. It openly fancy one to fancy one. Conscious portion or a hetero submission, 37, it is also from
Sribhumi, my lord,
to the satisfaction of Sribhumi. Okay, we'll put that in.
Deeply obliged.
Disposed of.
Item 10.
Listen. This item number, I know. Item number 4, listen. Item number 4 and item number 6 will also be disposed of, but don't put it as a disposed of because this not now, but it will be disposed of. So we have some similar kind of order. So with her, that is not there. So we have to dictate or we have to submit. That's why I picked an order. I think maybe not come. Yes.
Item
Item
10.
Yes, madam, your lordship idea rejected. Page 15.
50.
It is a case by charge sheet, charge also framed, but trial has not yet started.
Not yet started.
No, all the co-accused already granted bail. The present petitioner, my lord, your lordship, and the two petitioners, your lordship rejected page 50, your lordship will find. 10/4/25. 10/4/25. And your lordship here at this stage, I find that page 51 is your lordship's, my lord, page 51. After hearing the
I can understand. 2, 3, 4 accused persons were there and
next pages are there. All other, my lord. All other got bail, my lord. Now your lordship stated, my lord, further custodial interrogation is required. Already 267 days they are in custody, my lord. I think subject to your lordship thing, my lord, I think your lordship may consider, my lord. Because study have not started. How long it will, nobody knows that. Because
not yet started.
not yet. Right. So petitioner 1 is 267 days, petitioner number 2 is 251 days. And FIR is also all page 11, all the FIR names, it is already granted bail, my lord. Page 11, you also will find FIR, my lord. Total 5 persons named in the FIR, my lord. Page 11, Annexure 1. আমাদের ওটা একটু লিখে নেবে। আচ্ছা। Your lordship, number one, petition number one is number two, my lord. Accused number one and two before lordship, my lord. 3, 4, 5. All I have annexed, my lord. And allegation in the FIR, kindly see, my lord. Respect to the back to state that on 3/7 at about 4 p.m. while my husband so and so was coming, the above named accused person jointly surrounded my husband over a speed breaker near so and so outpost with a view to kill him, attacked with a dagger and caused grievous injuries on various parts of his body. After getting information to phone call, we immediately admitted him in so and so hospital in critical condition, but due to serious injuries, he was referred to Excel Care Hospital, Guwahati for better treatment. At present, he is undergoing treatment. Subsequently, he died in that hospital. Added section, my lord. So I think, my lord, your lordship may consider keeping in view of that. Nobody knows matter how long this one that will start. Charge was framed on 1/3/25. Charge framed. Part charge sheet was filed on 23/9/21. It was kindly noted. Part charge sheet, initial. And supplementary charge sheet filed on final charge sheet 18/1/25. Page 20, yes, page 30. And charge frame 1/3/25. March, April, May. No progress. If your lordship, but I think your lordship rejected at that stage, my lordship.
Yes, sir.
Also, earlier rejected lordship and trial records are also received and are going to the record possible rejected the prayer that we made.
Yes, that is the.
So lordship.
So far I can remember most probably these two are the main executor
Main executor.
of this matter. But as Mr. Chaudhary now took the plea that case is not progressing and he
Nothing at all.
not in-
No progress.
that is the issue. Otherwise, there are
Yes,
they
my
are
lord,
the
that was your
executed.
lordship. I am not
Executed
a
on the
merit
matter.
now.
Yes, obviously, most probably is there. So you want to call for the case record or what?
Your lordship asking, that's why he's saying. Same thing will come, my lord. Even suppose anything is against me, my lord. Whether my further custody is required, I give to your lordship, my lord. The record will say same thing, my lord, as your lordship already gone through this one.
As my knowledge, senior statement is that progress is not even yet.
Yes, not yet, not yet.
Empty will reveal it.
Mr. H.I. Chaudhary, the learned counsel, learned senior advocate, assisted by Mr. A.M. Ahmed, U.S. assistant A.M. Ahmed, the counsel for the petitioner, and also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. So this is an application under section so and so in connection with so and so. So it is submitted by Mr. Chaudhary that the earlier bail applications for these two petitioners were rejected by this court on perusal of the case record, case diary on 10/4/2025 in B application number 546 of the 2025. However, the other co-accused persons were already granted
All of
bail on same date, that is on 27/1/2025 on perusal of the case diary. Mr. Chaudhary further submitted that this is the second and subsequent bail application and which has been filed only on the ground that since 27/1/2025 there is no changes of status of the case and the case is still at the stage of evidence, but till date no evidence could be recorded by the prosecution. The accused petition number 1 and 2 are behind the bar since last 267 and 251 days respectively, and hence their further custodial detention may not be required for the may not be required for the disposal of the present case. However, the petitioners being the resident of the addressed locality, they will appear before the learned trial court below on each and every date to be fixed by the court. Next para, Mr. Goswami, the learned additional PP submitted in this regard that earlier bail application for these two petitioners were rejected on basis of the case diary and accordingly case record and case diary, and accordingly he insisted that these two the case record may be called for at this stage. Next para, hearing this submission made by learned counsel for both sides, I have also perused the case record, the case record. It is a fact that on 10/4/2025, the bail application for these two petitioners were rejected by this court on perusal of the case record and case diary, wherein it was seen that these two petitioners are the main executors of the murder plan. But till date, there is no evidence could be recorded by the prosecution, and considering all these aspects of the case and the consideration of the bail prayer for the other co-accused persons also, I find that further custodial detention may not be required for the present petitioners. However, they will appear before the learned trial court below on each and every date to be fixed by the court and will contest the case accordingly. And with the observation, corridor. This is to the satisfaction of which court? Session.
ও সেশন জাজ নলবো
Session to the satisfaction of session just not.
Item 11.
NDPS.
Yes.
Regular bail application, petitioner arrested on 2/1/25, 124 days in custody. The officer will find the FIR.
1/25.
2/1. 124 days today. But you will find the FIR case 17.
Page
17. Unsubmitted.
1 second.
Mary,
Yes.
I have the honor to inform you that on 23/12/2024 at around 2 p.m. one caller containing mobile number so introduced himself as Babul Assam for extremist organized Alpha Independent, demanded money from me over phone number so or else I have been faced consequences. Immediately I disconnected the call. The caller after that he also called me over WhatsApp, which includes video call, but I did not pick up the phone. After that, he had sent a video wherein a bomb and demand letter was being shown against me and one other businessman from our locality, namely Pradeep Kumar Dey and Binoy Bhushan Padra. Same demand had been given by the person on our group of Pradeep Dey and Binoy Bhushan Padra. We are have been facing this problem of demand from Alpha organization for the last few days, which interrupted our business as well as creating a panic situation. We have been threatened that they are planning to cause explosion in our business field if we do not pay the demand money before 5th of January 2025. Now, my lord, this was registered under section 10, 11, 13, 17 of the Unlawful Activities Prevention Act and section 5 of the Explosive Substances Act. So, my lord, I was arrested on next day, my lord. The forwarding letter your lordship will find as page 18, my lord. I am Bolin Gogoi, my lord. Page 18.
Yes.
Grounded with your lordship will find, my lord.
Yes.
The confession of the arrested accused person have been headed recovery of parts of bomb material, that is battery, from the possession of arrested accused Bharat Hazari at his house. The mobile number which has been used to extort money from the companion and other victim has been found by Sri Bharat Hazari in his personal mobile phone. Next line, one of the main accused of the case, Bitupon Gogoi, was taken to the house of Bharat Hazari by the arrested accused Bolin Gogoi, and all are found to belong to the same nexus involved in the case. My implication says that I took that he took on to the house of Harpatri. And I have also annexed the seizure list minute, page 20, 22 and 23 minutes. One 16 GB pen drive, which had contained video footage indicating existence of a bomb having demand letter in name of the company and duration of video is 44 seconds. 3 numbers of printout screenshot stub paper of WhatsApp from stub paper monument sensor. So all these it was transmitted from Bharat Hazar email. Your WhatsApp has seen in the forwarding report. My implication to that extent that I took the allegation is I took one of the accused to the house of the unauthorized. One
UFP
124 days in custody. By order of the session court by 2/4/2025, my lord, will also will find at page 21, part of this order, my lord.
And after appraisal of the case,
After appraisal of the case, I find by order dated 2/4/2025 trial court, this court already allowed the prayer of the public prosecutor for extension of period of detention of the accused for another 60 days. Otherwise, will 90 days is over now. I mean the custody for 124, that may be considered. And the implication only for my lord, accompanying the accused to the house of the other accused. Otherwise, no allegation against me regarding that explosive substance or demand letter.
But I don't know, it's probably perusal of the case there
My
will be required, I think,
My lord.
at this stage. Otherwise, obviously, you are in considerable period in this because, but most probably extension is also there.
Yes, extension is there
so
by
it's-
invoking for section 43.
After appraisal of the case, the exception was made.
Extension was there. Yes, when it can be called for, because he is in custody for 124 days. Yeah?
124 days, my lord. It's from Duliazan, my lord. 21. 21. I could say 21.
21. For the case diary. Any other report is also there, any FSL report will be required here? If those, because
In
just
fact,
those-
only pen drive and that print out,
okay, then
what will be there?
case diary be called for along with FSL report, if any,
Right.
just see. 21/5. we have
21.
listed. Okay.
Outlet.
Item 12.
Yes.
18 years boy, my lord.
Hmm.
He is in an NDPS case, my lord. Merit, my lord, you'll also kind to see. In the FIR, it is stated that it was recovered from the house of one Shamsul Haq. Until Islam. My kindly see page 14, my page 14.
Counsel Islam.
Yeah,
Yes.
yeah, yes, my lord. Page 14.
Hmm.
On reaching the spot at the house of Shamsul Islam, as shown by the, your lordship, what is my third, fourth? On reaching, I'm reading. On reaching the spot at the house of Shamsul Islam, I am not Shamsul Islam, my lord. As shown by the source, we see, I've seen that 2-3 persons were dealing drugs. After that, I, along with my police party, conducted raid in the house of Shamsul Islam and able to detain one suspected person, so and so, this is present prisoner. However, 2-3 suspected persons were able to flee away from the spot. Before starting the search, we have called out to local influence so and so, witness namely so and so. We identified ourselves and have shown my pocket inside and so and so, so and so. Then the suspected person, namely Burhanuddin, was apprehended, your lordship. Kindly note, my lord. And on spot interrogation about the drugs, he admitted and revealed that the drugs are of one Samon Ahmad and which have been kept concealed into the red black color plastic being shown by the Burhanuddin. There are 25 numbers of soft cases were recovered from the veranda of Shamsul Islam house at Deokuli village, and Abdul Halim was supposed to deliver the so and so, so and so. Then in the forwarding report, my lord, it is said that it was found in the vehicle. Kindly see page 16, my lord. page 16. The accused persons in the FIR named accused who was found involved into the case and was caught for illegally carrying narcotic drugs which was found concealed into the vehicle and recovered and seized from their possession and kept inside the vehicle in presence of signed witnesses. Quite contradiction, my lord. So this is on merit. Then you can be page 30. About here in this case, my lord, already he is almost 1 year in custody. And other person fled away. So my lord, charge has not been yet paid, my lord. Now you will kindly see page 30. And normal the grounds, my lord. Page 30, page 0. This is copy of the certified copy. That's your lordship got page 30. Kindly see, Madam Burhanuddin, you are hereby informed. Then your lordship will find arrest memo. Next page. (31A) type copy, 32 is the minor copy. Then again, my your lord will find inspection memo, page 33. Type copy. Nothing is there, my lord. So on page 30 is the main, my lord. The certificate copy, that is the copy of that here, my lord.
Do you have any other certified copy?
No, other we don't have, my lord. This is the copy we are having, my lord.
It's not a certified copy, I think, or certified copy.
Yeah, it is certified, my lord. Kindly see, my lord. Page 30, bottom.
Bottom will compared by certified to be true.
See, it is there compared by your lordship. Kindly see.
And date of application is there above.
Above date of application is also the one, top.
Yes,
18, just 18 years, man. At the time of he was 17 years, man. Now he's 18 years.
your petitioners, oh, two names are there. Abdul Halim is also one name.
Burhanuddin Elias Abdul Halim.
Elias Abdul Halim.
One petition.
One petition. It is not one.
As per Sasiri, effects of conscious possession recovered from the conscious in a Burhanuddin. This petition.
That he found he brought some contradictory regarding DFR from DFR as well as
And
from
the
the
foreign
expert.
report. In the Sasiri also it was stated as a vehicle was in the Tata Magic Iris being racing AS111cc.
I have no relation with the vehicle, man.
For transporting the contraband substance.
Vehicle belongs to
Jamal answer.
one Jamal Ansar. Who you say?
Jamaluddin Ansari.
Jamaluddin Ansar.
Mr. H.I. Chaudhary, the learned counsel for the petitioner, the learned senior advocate for the petitioner, assisted by Mr. I.U. Chaudhary, and also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so.
Jamal Ansar.
It is submitted by Mr. Chaudhary, the learned senior advocate, that the present accused petitioner is innocent and he is no way involved in the alleged offense. Further, he submitted that as per the FIR, the contraband was recovered from the house of one Baranda of one house of one Samsul is Baranda of the house of one Samsul Islam. But as per the foreign report, the recovery was made from a vehicle, which is a contradictory statement made by the investigating officer. Further, he submitted that accused was arrested in connection with this case. When it was arrested?
He was arrested on 22/5/25.
22/5?
348 days.
22/5/24.
22/5/24.
22/5/24. Case has already been charge sheeted?
Yes, charge sheeted and nothing more. because some absconders are there.
Case has already been charge sheeted and he is in
Charge sheet
custody
file
since
number
20
16/11/24.
22/05/2024 and his CS has already been filed on 16/11/2024. But the no charge was framed till date as some of the accused persons are still absconding. Accordingly, he submitted that considering his period of detention also, his prayer may be considered. Mr. Chaudhary further raised the issue of non-communication of the grounds of arrest while issuing notice under section so and so so and so 41. But the submission I give. In this regard, Mr. Kusami, the learned additional PP, submitted that the present accused petitioner is very much involved in the alleged offense. From the forwarding report as well as from the charge sheet also, it is seen that the contraband was recovered from his conscious person, that is from a vehicle. He further submitted that case has already been charge sheeted. However, the charge could not be framed due to absconding of some of the accused persons. But 37 times raise query. To whose satisfaction it has to be
Special just Sribhumi.
disposed of for special just review. Okay.
Item 13.
It is a case, my lord, of the matrimonial dispute has given color of NDPS, my lord. I just take your lordships to FIR, my lord.
And where is that page?
Yes.
Page?
FIR is page, my lord. Your lordship will find page 19, 19. Just a background, I am saying it will be clear, my lord. These two brothers, my lord.
Just a second.
Just a background, it will be made clear, my lord. The elder brother of these two petitioners married, my lord, one lady. And the marriage took place by the 20, long back by the 2002. 2002. She left in December 21 and filed one 498A case, my lord. Thereafter, again by negotiation, she came back. Then again she went. Thereafter, again filed one domestic violence case, my lord. On 24/4/24, domestic violence case. Thereafter, what happened about they have actually involved by telephonic contact, my lord. They wanted to settle the matter from the wife's side. And they called the present petitioners, my lord. That person is my elder brother, my lord. Your lordship, I will show from that here, my lord. And they called us to go to family along with present petitioners, along with some others. Went to that family. And there, my lord, there, actually, they have tied us, informed the police. Police came and some, my lord, cough syrup, 9 bottle cough syrup were kept. Police came and I was handed over to the petitioners are handed over to the police. Now I take your lordship to your lordship will see the name, just this story. And other grounds is also there, my lord. 47, 48 is also there. On many times saying, my lord, your lordship will find that, my lord, take your lordship kindly see. Just 48 case, my lord, 48 case, my lord. Just page 25, my lord. Just for the purpose of name, my lord. Relation. Your lordship will page 25. The format of FIR, my lord. 6 column 6, my lord. Maria Khatun. Fathers Abdus Samad. That is very important, my lord. Fathers Abdus Samad. Now your lordship will find next is a question by page 26. Sia case, my lord. That Sia case file. The Sumogali is the present deponent, our elder brother, my lord. So Sumogali, son of Falusha. Just to show that we are the brothers of Sumogali, my lord. Deponent one. Thereafter, again, your lordship will now come to FIR, my lord. 21, page 19. Your Lordship, with reference subject above, the information was received on 22/3/25 at 6:45 PM. The two persons, namely by the present petitioner, Shahjahan Sheikh and Surat Jamal, have been apprehended by public at so-and-so who were carrying suspected drugs. The information received suggested, Your Lordship, likely operation of entry, search, seizure. Accordingly, a written authorization to me was issued by the so-and-so, so-and-so, so-and-so. I, along with the police party, proceeded so-and-so, and we reached the destination. The below mentioned persons were approached by me, who are found available in the nearest location. They are explained. Name, Your Lordship, kindly see, Sadagar Ali Pramanic, and number 2, Ashraful Haq, son of Abdul Samad. Brother of that wife, my Abdul Samad, Your Lordship has seen the daughter of Abdul Samad. So he was one of the witnesses, and he was found there. Then Your Lordship will find name of the address of the person, might have that it's two person. Now I take Your Lordship to forwarding report. Then I take Your Lordship to 47 notice, my etc. Find this in the page 30, page 30. Oh, no, my page 28, man. Page 28. Each of the officer of the so-and-so, Your Lordship, notice arrest under section 47. Your Lordship, what is one? Top. Then, particulars of the arrested so-and-so, so-and-so, detailed grounds, Your Lordship, kindly see. Accused person FIR name, accused persons caught red-handed, accused persons confessed their guilt. Arrested from the house of their matrimonial house, my wife. And then Your Lordship will find 47 regarding petition number 2. This is page 20.
Grounds of arrest were communicated.
Whether it is ground of on in the sense which the might have behind and whether it is
Whatever, ground is dead.
simply say your name in the FIR, caught red-handed. Test their guilt before police. That is normal one, man. This is the same thing forwarding report. Same thing when in the forwarding. That is not sufficient, man. This is the factual part, my lord. That part, my lord. Then Your Lordship will find that 48 notice. Then inspection memo, page 32. Page 33, inspection memo. Arrest memo, page 10. Sorry, page 34. All are 38 will be my lord.
And otherwise, during the search, recovery was made from them.
No, that is why I have stated, my lord, how it happened. Your Lordship will find that our my request. Paragraph minus 6, I have details, I have given paragraph 6 of the petition. And that person was serving in the my army. He had to resign, take voluntary retirement because of matrimonial dispute. My elder brother, our elder brother. Only to teach a lesson to that, my lord, and married to 2002, my.
Yes, Goswami, anything?
Lordship. Regarding the arrest complaint, other things are nothing to say, Lordship. Other than recovery was made from the prisoner behind the result story against them, that is might be true or may not
And
be.
grounds of arrest are being also mentioned.
Mentioned, Lordship. But in the
That is the as per forwarding report of same grounds.
but in the arrest petition 48,
There are mentioned.
Not mentioned here. 47, 14.
47.
47 is mentioned. We have not gone through.
Page 28.
ইয়াতে কৈছে, actually,
It was just like my daughter, that forwarding it. The Lord kindly say to forwarding it.
Even looks.
Same thing, ground report, my page 22 is the forwarding report.
That is communicated in the 47.
Actually, they are my notes, that manufacture story or a whole story, one name actually one of this.
Heard Mr. H.I. Chaudhary, the learned senior advocate, assisted by Mr.
S. Ahmed.
S.S. Ahmed, the learned counsel for the petitioners, and also heard Mr. D.B. Gusami, the learned additional PP, appearing on behalf of state respondent. This is an application under section so-and-so in connection with so-and-so. It is submitted by Mr. Chaudhary, the learned counsel for the petitioner, that due to some matrimonial disputes between the elder brother of the petitioners along with his wife, the present case has been false against him when he simply went to the house of the wife of his wife of their elder brother to settle the matrimonial dispute. However, the present petitioners were got arrested in connection with this case on 23/3/2025, and since then they are in custody. Thus, the I also got sufficient time for their custodial interrogation. Mr. Chaudhary further Mr. Chaudhary further submitted that there was no proper mentioning of grounds of arrest in the notices issued under section 47, 48, vis-a-vis the arrest memo and the inspections memos issued to the present petitioners at the time of their arrest. He further submitted that the grounds of arrest mentioned in the notice under section 47 BNSS cannot be considered as the proper grounds of arrest, which is similar with the ground of arrest mentioned in the arrest memo. Further, he submitted that no grounds of arrest have been mentioned in the notice issued to the family members of the present petitioners under section 48 of the BNSS. Next, Mr. Gusami, the learned additional PP, submitted in this regard that the contraband was recovered from the conscious possession of the accused petitioners, even though some matrimonial though some matrimonial disputes etc. were brought by the petitioner, but the fact is that the recovery was made from the conscious possession of the accused petitioners. Or 37 raised probability one, the case is still at the stage of investigation, and there are some more persons to be named in connection with this case, as it is an organized crime. Raised to a same point. Okay, we'll pass the order.
What?
Item 14.
Last point.
The section inserted, my lord, all are 5 years, my lord. Today is 43 days, my lord. Can you have the case diary, my lord, short date? From Bosista, my lord.
From Bosista.
Bosista, my lord.
Yes.
Friday, my lord.
Friday is 9th. 9th, so we have matters. So how many days he is in custody now?
Today is exactly 43 days.
43 days.
Yes, my lord, 5 years punishment.
It's okay. 9, you can be able to produce the case diary.
Try to.
Okay, then CD corridor or 9th corridor. Okay, we're calling for the case.
I'm obliged.
and which is pending before the special judge come additional district and the session judge Dhubri. Lordship, we are arrested on 24/8/2024, Lordship. As on today, Lordship, 254 days behind the bar. Lordship, in case 37, Lordship, notice under section 47, 37, 38, and 39, and 40, 38 BNSS. There should be no grounds are mentioned in the notice. Lordship. Moreover, Lordship, 687 grams of tramadol seized from co-accused Sachin Kumar and Firoz Ahmed, Lordship. And on the basis of co-accused statement, we are in the behind the bars, Lordship.
What is the stage of the case at present?
Evidence is this, Lordship.
Evidence stage.
Evidence is
Is there any evidence recorded?
not
till
been
date?
taken as per my instruction, nothing taken.
Yes. good.
Since it is a solicited case, my lord, so may I pay my screen copy may be called for my lord.
Lordship, I have managed the copy of notice, Lordship. Certificate copy, Lordship.
Otherwise, if he goes by that ground of arrest, then certificate copies they have annexed already.
Yes, my lord. Ground of arrest, my lord, in the notice, it is not mentioned, my lord, but in the forwarding report, lordship, may kindly see page number 19, my lord. So they are the, my lord, main kingpin, my lord. They supply the drugs, my lord, to the accused person who were caught red-handed, my lord. They are the supplier, my lord.
As per the co-accused, as per the co-accused statement, Lordship.
Page number 19, my lord, grounds of arrest.
Yes. They're the main drug dealer.
They are the main drug. And co-accused person, my lord, they are from, not from Assam, my lord, they are from Bihar, my lord. They came to Assam, my lord, to collect the drugs from this person.
No, Lordship, they are from Gauripur district, Dhubri,
So
Lordship.
one is Gauripur district, another accused Sachin Kumar.
Lordship, actually, Sachin Kumar and Firoz Ahmed is the co-accused person, Lordship.
No, he's not on there. He is saying that those are from the out of states. They are not from Assam. And they came to this state only to collect drugs from you as you are the kingpin. You are the main delivery of the drugs. Yes, any other submission?
Lordship, I may be allowed to go on bail with the Lordship. As already I have annexed the certificate copy. I don't know this, Lordship. And
Mr.
already,
Purva, we are dealing on to these cases mainly on the grounds of arrest. What have any alternative? Rather, we know you know me also. It is also well known to me. We are today are we going to deliver 6 numbers of the orders also in that case of this conscious position. But here this is not the conscious position. I think
Lordship.
you are Mr.
Sanu Hussain.
Huh?
Sanu Hussain.
Sanu Hussain. His name is not here.
Post list is there, Lordship. Sanu.
What is it? Oh, I say yes. Heard Mr. Sanu Hussain, the learned counsel for the petition, and also heard Mr. R.J. Burwa, the learned additional PP appearing on behalf of state respondent. This is an application and section so and so in connection with so and so. Stop. It is submitted by Mr. Hussain that the present two accused petitioners got arrested in connection with this case on 24/8/2024, and since then they are in custody. The case is at the stage of evidence, but till that no evidence could be recorded by the prosecution. Most of you further submitted that they were arrested in connection with this case only on the basis of statement made by the co-accused persons, and no recovery was made from the conscious position of the present accused petitioners. To fencing logai dibo yate. Next para. Tapsat likho. Next para. He further raised the issue of non-punishing of the ground of arrest while issuing the notice under section 47 and 48 BNSS to both the petitioners, which is mandatorily required and in violation constitutes so and so forth. Next para, Mr. Borwa, the learned additional PP submitted in this regard that the recovery may not be from the conscious position of the accused petitioners, but they are the main kingpin of the entire case, and the other two co-accused persons. We came to Assam only to collect the drugs from these two petitioners, who are the main drug dealer. Mr. Borwa accordingly submitted that case has already been charged sheeted and it is at the stage of evidence, and thus there is every probability of completion of the trial within a reasonable period. Mr. Borwa further submitted that too, the grounds of arrest were not properly mentioned in the notice issued under section 47 and 48 BNSS, but the grounds of arrest are being explained at the time of in the forwarding report. Or baki oral submission take over every submission, same submission we can record it. This cases of from which district?
Special just from additional district and section just Dhubri.
Dhubri. It's suspicion. Okay, we're disposed. Order will be passed.
For motion item 17.
The Lordship, second time bail Lordship, earlier rejected by this honorable Lordship, order dated 2/4/25, page 17 Lordship.
Page 17.
17, page 17. 11% acting earlier rejected by this honorable court. 17 pesos.
Yes, Borwa earlier rejected. That is, they are the peddler, I think.
They are a peddler, my lord, see the, my lord, new ground, my lord.
Yes,
Because this is a successive application, my lord. There has to be new ground.
New ground has to be there. New ground has.
New ground is, my lord, this, that's a, my lord. That is a, my lord, what is this? I do not know, my lord. It cannot be a certificate, my lord.
What
Actually,
certificate?
So kindly see, my lord, page number 20 of the bail application.
20.
20, my lord. So this is cannot be a certificate, my lord, as per my
Lordship, actually, petitioner admitted in the rehabilitation center, Lordship. Is a educated person, Lordship. So my ground, Lordship.
There is nothing, my lord. There is no reference number, my lord. Only date is there, my lord. No skill, my lord.
Issued by the
Cannot
Lordship.
be considered, my lord.
And that apart, if it is this is produced before the I don't know at this stage. We can call for the at best call for the case diary. Otherwise, we don't have anything.
Lordship, therefore, diary will be called for Lordship.
Pardon?
Diary will be called for Lordship. At least at this diary will be called for Lordship.
Yes, we are calling for the case diary. It can be listed when, Borwa?
13, my lord.
1-3.
Or
1-3. Lots of matters are there. In
Then
fact,
19, my lord.
19,
Yes,
19, 20. Okay, 19.
Of Lordship.
CD call.
Item 18.
Yes, yes.
Lordship, this is an application under section 482 for grant of pre-arrest bail in connection with Hojai PS case number 91 of 2025, registered under sections 318 subsection 4 and 316 subsection 2. Criminal breach of trust and cheating, that is Lordship. Lordship, may kindly come to the FIR, which is at page number 12, the translated version of the FIR. May I read the... The informant happens to be from Indore. So, sir, with due respect and humble submission, it is to inform that I am a businessman. I got acquainted with the accused person through business relation. That on 10 March 2025, the accused person promised to give me broom, and in exchange of that, I, in the name of purchasing broom, gave him an amount of rupees 2 crore 40 lakhs between the period of 10 March 2025 to 17 March 2025. But till date, the accused person did not provide me any kind of broom. I have contacted the accused person several times, but the accused person made excuses saying that he will provide me the broom by today or tomorrow, but he did not provide me any kind of broom. I have asked the accused person either to give me broom or money, but instead of giving me goods, the accused person has been giving me false hopes. I doubt that the accused person is trying to misuse my rupees 2 crore 40 lakhs. Therefore, your good self may please help me to recover the above mentioned amount of money from the accused person. So, Lordship, this is the prayer for recovery of money. Lordship, a civil dispute, even if we take it at its face value and presume everything to be true, this is a civil dispute that has been given a criminal favor. In this regard, Lordship, I have a judgment, a very recent judgment by the Honorable Supreme Court. In fact, I'll be relying on two judgments. Lordship, the first judgment is Radhesham and others versus State of Rajasthan. The relevant paragraphs are 6, 9, and 13. The crux of this judgment is that if it is a civil dispute and a civil remedy is available, the criminal proceedings cannot be initiated. So may I read the relevant portions 6, 9, and 13? Lordship, 6 says, as already indicated above, a perusal of the complaint which has been registered as the FIR does not spell out any element or ingredient of cheating or breach of trust. Mere non-performance of an agreement to sell by itself does not amount to cheating and breach of trust. Respondent number 2 has adequate remedy of filing a civil suit for relief of specific performance of a contract, which he has already availed and the suit is still pending. The FIR only appears to be an arm-twisting mechanism to pressurize the appellants to execute the sale deed. The matter is slightly different, but the crux is same. Now, Lordship will see paragraph 9 from the fair perusal of the FIR. That is page number 7 of 10, Lordship. Paragraph 9 of the judgment. From the bare perusal of the FIR, it is evident that there was no act of cheating. That is, the complainant was nowhere fraudulently induced or dishonestly deceived by the appellants. The commercial transaction took place between the parties, which is also alleged in the FIR, during which the parties consensually agreed for the sale of the property of the appellant so and so. The default in payment of the loan dues on the part of appellant is not reflective. Mere non-registration, this is not relevant, Lordship. The delivery of the advance payment towards consideration was made in furtherance of an agreement to sell, and it is not the case of the respondent that he was in any way deceived or duped to make such payments. That allegation otherwise is not there even in the FIR, Lordship. The prayer is for recovery of money. So, Lordship, all in all, Lordship may grant interim on this ground that otherwise criminal proceedings do not lie. If your Lordship may kindly see the other judgment, that is Rikhab, Birani and another versus State of Uttar Pradesh. This is fairly recent, and if your Lordship will see page 4. No, sorry, Lordship, page 6. Page 6, I've marked the paragraphs as A, B, and C since there is no numbering. Lordship could find the relevant portions. So firstly, Lordship, the offense of cheating and criminal breach of trust, otherwise they are not mutually sustainable. So that from that on, I'm reading out paragraph A. It says this court in Delhi Race Club versus State of UP highlighted the fine distinction between the offenses of criminal breach of trust and cheating, observing that the two are antithetical in nature and cannot coexist simultaneously. Police officers and courts must carefully apply their minds to determine whether the allegations genuinely constitute the specific offense alleged. Secondly, why section 318 does not lie in this case? In Kunti and another versus State of UP and so, wherein it was observed that a breach of contract does not give rise to criminal prosecution for cheating unless fraudulent or dishonest intention is shown right at the beginning of the transaction. Merely on the allegation of failure to keep a promise, which is alleged in our case, will not be enough to intimate criminal proceeding. Thus, the dishonest intention on the part of the party who is alleged to have committed the offense of cheating should be established at the time of entry. C is also crucial. It is the duty and obligation of the court to exercise a great deal of caution in issuing process, particularly when the matter is essentially of civil nature. The prevalent impression that civil remedies, being time-consuming, do not adequately protect the interests of creditors or lenders should be discouraged and rejected, as criminal procedure cannot be used to apply pressure. Lordship, in our case also, I was merely the facilitator, and merely to apply pressure on me, this FIR has been lodged against me. Lordship may kindly grant me interim.
Yes.
Lordship may kindly peruse the FIR, my lord, page number 15, my lord. What my learned pen has submitted, my lord. There is no ingredients of cheating, my lord. Lordship may kindly see. My lord, I am reading the FIR, my lord, second paragraph. ব্যৱসায় সূত্ৰে মই পদকীয়াৰ লগত চিনাকি যোৱা 10-3-2025 তাৰিখে চিনাকি যোৱা 10-3-2025 তাৰিখে পদকীয়াই মোক ঝাৰু দিম বুলি কয় তাৰ বিনিময়ত মই যোৱা 20-3-25 তাৰিখৰ পৰা 10-3-25 তাৰিখৰ পৰা 17-3-25 তাৰিখৰ ভিতৰত মই পদকীয়াক ঝাৰু ক্ৰয়ৰ নামত সৰ্বমুঠ 2,40 লাখ টকা আদায় দিওঁ যদিও পদকীয়াই মোক আজি পৰ্যন্ত কোনো ধৰণৰ ঝাৰু দিয়া নাই From the FIR, it is very clear, my lord, that he took the money in order to, my lord, supply the, my lord, what is called, my lord, broom, my lord, yes. So my humble sum, my lord, let the case diary be called for, my lord, it will be clear from the case diary, my lord. Because the amount he has paid, my lord, around 2 crores for 60 lakhs.
It's quite a big amount.
Let the case diary call for, my lord, we will pay the case diary.
Irrespective of the amount, whether the offense is made out or not, that has to be seen at this stage. So my humble submission is that
this is not a quasi petition, my lord.
Yes,
This is a
yes,
bail
yes.
application.
Considering
So let the, my lord, case diary be called for, my lord. So there are materials in the FIR, my lord. Because he said, my lord, that he will provide the, my lord, boom, my lord. That is why he took the money, my lord, that it is a huge amount, my lord. It is not that, my lord, some part of the money has been delivered after that, my lord, he has not paid, my lord. It is a huge amount of money paid to the accused person, my lord, but he has not supplied the money.
By the way, you have not denied that you have been paid with 2 crores
no,
40
I was
lakhs.
the facilitator, Lordship. I have not been paid 2 crore 40 lakhs. In fact, I have made specific amendment in the application also. I was the facilitator in the business dealings. So that much is there, but apart from that, there was no broom or it was not there. I have previous business relations.
No, this agreement was not with you.
Agreement, there is another seller, Lordship. There's another buyer. So I was the facilitator. So merely to put pressure on me, the person happens to be from Indore.
No, you are the Ravi Prakash Gupta.
Yes, I'm Ravi Prakash.
Ah,
He is named in the FIR, my lord.
I'm the named. I'm the named person. The other persons, nobody has been named. But I was the facilitator. That is the
How
instruction.
can you know? Here though it is from you, it is seen that there was an agreement.
Yes.
Or business relationship with you, and then in that 2% to that only you have contacted with the accused persons and then the broom was supposed to deliver by you. Otherwise, we don't know anything about it. From the FIR only we are saying.
Yes.
You may be a facilitator, but here you are the named accused.
Yes. Lordship, my limited submission is whether non-delivery of goods will amount to an offense under section 420 or 318 or 316. Lord.
Before that, my lord, that person will come, my lord. He has assured to, my lord, supply the broom, my lord. That is why he has paid money, my lord. That is, he is supplied or not, that will come afterwards, my lord.
Or there is no mention from your side also that you are still ready to return the money, or you are still ready. That is also not there within your petition.
Yes. Otherwise, Lordship, I am not the custodian of the money, right? I don't have the money. So there is no, I was the facilitator.
Facilitator means, my lord, he is the middleman, my lord.
Yes. Merely to put pressure on me. Otherwise, I will comply with the investigation also, Lordship.
My lord, more dangerous, my lord, than the other accused person, my lord.
Otherwise, Lordship, if something like that comes out, then Lordship may pass appropriate orders, but at this stage, I will comply with the investigation
Let
also.
the case diary come, my lord, after that.
In fact, if your Lordship will allow me to read up at page number 8 of the second judgment that I was reading, there's another amendment as regards 406, Lordship. If I may be allowed, the paragraph 36, page number 8 of this judgment, Rekha Birani. May I read the Lordship? I've marked the relevant portion. It says, an offense under section 406 of the IPC, which is corresponding to the breach of trust, requires entrustment, which carries the implication that the person handing over any property or on whose behalf the property is handed over continues to be the owner of the said property. Further, the person handing over the property must have confidence in the person taking the property to create a fiduciary relationship between them. A normal transaction of sale or exchange of money consideration does not amount to entrustment. Clearly, the charge offense of section 406 IPC is not even remotely made up.
No, this is the case basically that 406 and 420 may not come together because one is for entrustment, other one is for cheating. That may be the one position for major. But the question is that whether you had any such intention, criminal intention, or the malified intention to ditch the or the to cheat the, that is not, we cannot see from here. Okay, then we see. Heard Mr. Y. Kothari, the learned counsel for the petitioner, and also heard Mr. R.J. Borba, the learned additional PP, appearing on behalf of state respondent. And this is an application under section so and so in connection with so and so. Next, it is submitted by Mr. Kothari, the counsel for the petitioner, that from the plain reading of the FI itself, it is seen that the case is of civil in nature, wherein a criminal color has been given. It is merely a simple case of agreement for sale, wherein it is alleged that the complainant had paid 2 crores 40 lakhs to the present petitioner for the purchase of broom. But there is but simple an agreement for sale cannot but merely the allegation of failure to keep the promise will not enough to initiate a criminal proceeding unless there is an intention to cheat the person from the very inception of the agreement. He further submitted that from the FI itself, it is seen that the petitioner was also promised to give the broom, but it is a fact that it was not provided to the complainant till date. Further, he submitted that he is not the person with whom the agreement was made, but only a facilitator, and the money or the broom is not directly in possession of the present petitioner. However, he is ready and willing to appear before the learned trial court below to extend his cooperation in the further investigation of this case if he is granted with the privilege of interim pre-arrest bail. In that context, he also relied through decision of so and so court. Next, Mr. Borba, the learned additional PP submitted in this regard that from the FI itself, it is seen that the present petitioner is in one of the FI name accused, and the money was given to the present petitioner amounting to rupees 2 crores 40 lakhs with the intention to purchase broom, but till that he has not been, the complainant was not provided with any broom in spite of receiving a huge amount of money of 2 crores 40 lakhs from the informant. Accordingly, Mr. Borba submitted that it's insisted to call for the case diary to know the actual fact of the case, and he submitted that at this stage the intention of the present petitioner also cannot be ascertained, simply perusing the FIR. Next, considering the entire submission made by learned counsel for both sides, considering all other aspects of the case, I find that one chance may be given to the present petitioner to extend his cooperation with the investigating officer in further investigation of this case. Accordingly, some interim protection is provided to the present petitioner in form of interim so and so. Okay, you'll be under interim protection till next date of lifting. When it can be listed for?
It is 28/5, my lord.
List on 28/5. Cooperate, there will be some conditions abide by all the conditions.
For bail hearing, item 19 and 20.
After same FIR?
My lord, same. My lord, your lordship, kindly see, my lord, that first office order dated, my lord, 10/4/25. Some clarification was sought for, my lord.
Office
10/4/25. Regarding case number, my lord.
বন্ধ করে দেন এসিটো, এসিও বন্ধ করে দেন, চলাই দিব, গরম গরম লাগিব। ফ্যানটো বন্ধ করে দিলে এসিটো চলছে। Yes, there was some clarification.
Yes, you look at the time of passing, my lord, this order was about to be passed. And one thing was to point out that at the time of passing order while going through the section 50 CRPC notice issued to the petitioner, it reveals that the case was originally registered by the Rathabari PS case number 28823. Your lordship got it, madam?
No, you're reading office note or
No, your
Order.
court's order, court order.
where is the order? Order dated
10/4/25. Your lordship got it.
Yes.
10/4/25. Part so and so, my lord. At the time of passing order while going through the section 50 CRPC notice issued to the petitioner, it reveals that the case was originally registered by the Rathabari PS case number so and so. Subsequently put the case number 0124 by overwriting the case number so and so. No clarification of such overwriting is available in the trial court. Registry to obtain such clarification from the concerned police station to learn a session judge so and so in connection with so and so. Then your lordship kindly see order dated 25/4/25. By communication dated 24/4/25, the learned session judge forwarded the clarification report of the Rathabari case number indicating that Inspector Officer so and so by number so and so on due verification of the records in the register in the Rathabari case clarified that petitioners have been arrested in connection with Rathabari case number 0124. Wherein charge sheet was submitted on 31st/3/24 by charge sheet number so and so. So that was clarified, my. Now on the prayer of the land council of the petitioner list these matters on 2/4/25 before the appropriate parents. Now your lordship will find, my lord, if you also kindly see FIR. On the page 17, your lordship.
So you are as per the clarification, you got arrested in Rathabari PS case number 01.
01. It is actually 01, my lord. Only thing initial was not there, man. That's why it took about 1 month for clarification. 01, man. Earlier at 288 it was written. Your
So and then this both the petition why take together in this two 19 and 20.
Oh, that is one of two accused. Your lordship kindly see page 17. I will explain.
You are representing 20.
I am for item number 20.
20. Okay.
Similar requirement.
Same FIR. Page 17, your lordship kindly. Page 17. FIR last page one. Your lordship, page 17.
Yes.
After completion of all the formalities, the police party departed from the PO at so and so and returned to the police station with the seized items apprehended person, namely 3 persons name of the Ahmad. Miftagul Haq, Asragul Haq, Abdul Manaf, present petitioner. So this Miftagul, Asragul already got bail. I have annexed my your loss. And handed over the seized article to the so and so. It will also be noted that during interrogation of the driver Miftagul Haq, he revealed that on 31st/12/23 morning, Miagun Nasa, wife of Asaruddin, gave him the narcotic drugs to deliver it to Anipur here. He also revealed that Asaruddin and Matiur Rahman, item 21, Matiur Rahman is item 20. Asaruddin and Matiur Rahman few days ago brought narcotic drugs from Mizoram area to sell it at different locations of Qatar and Koringal. I am none of them, my lord, here. On the basis of new imports, along with the police personnel headed so and so, I, along with the detailed staff, arrived at Kalibari. On arrival, along with the Kalibari staff, conducted the route different location and finally apprehended Matiur Rahman from his house. At around 1 p.m., I along with so and so. So 6 persons are named. Your lord kindness, 6 persons. Number 1 is Miftagul Haq, already got bail. Number Asragul Haq, already got bail, my lord. Asragul, page 64, your lordship filed. And Abdul Manaf is present petitioner, Matiur present petitioner. Miagun Nasa, fine, she also got bail. Asaruddin, he was absconded. Subsequently, he surrendered. Now he is in custody, my lord. Now your lordship will find next. Your lordship's order is by the subsequent additional affidavit I have filed, your lordship. And is it before lordship, my lord? Additional affidavit. It starts from 49, my lord. Your lordship kindly see page 53.
Yes.
Page 53, notice under section 50, my lord. Your lordship, you are hereby informed, the present petitioner, item number 19. Then your lordship will find arrest memo. Abdul Manar. Then your lordship's order, page 55 onwards. This is regarding Niagunnesa, page 56. Then page 64. Page 64. Asarul Haq. Muftarul Haq. Page 73 now. Same matter, same case, same year, same number, everything is same. And all these 3% except Niagon, rest matter 64 and 73 on the same footing, my lord. Niagonessa subsequently she was found that she was the main person by now, but anyway she was granted bail, my lord. But we stand on the same footing of page 64 and 73. Same footing. And present footing, he was my lord, only he was a passenger in an Alto. 100 rupees he paid, my lord, nothing. About him also, police also did not ask for his remand, nothing at all, my.
He is, as per you, who is he? Who is he?
He had paid 100 rupees to go from this place to one Anipur area, my. From the
He is a
roadside.
driver.
No, he is none of them, passenger, my. It was auto vehicle, my lord. One day driver was going, and on the road, my lord, this passenger, he got in, my lord. By paying 100 rupees, my lord, I have stated here, paragraph 6, my lord. Paragraph 6, details I have given.
6 when he is in custody?
11/24. 1 year, 4 months. 4 days. Same, all are same, my lord. 65, 64, and 73. On the same date, they are arrested by these 3 persons.
Yes, Burwani.
My lord, in both the case, my lord, the first case, my lord, item number 20, my lord, accused person is Abdul Manaf, my lord.
Item 19,
Item 19, my lord. Now, my lord, from this, my lord, forwarding report, FIR, my lord, the contravenor was recovered from 3 persons, my lord. One is, my lord, Mitraful Haq, another is Asraful Haq, and the number 3 is Abdul Manaf, my lord. That is the, my lord, petitioner, my lord. So from their position, my lord, recovery was made, my lord. Now, as far as the, my lord, second bail application is concerned, my lord, Motiur Rahman, my lord, he has been arrested on the basis of the, my lord, implication of the co-accused, my lord. That is, my lord, lordship will find at page number 17, my lord. My learned senior friend has already read, my lord. After completion of these formalities, the police party departed from the PO at 4:50 p.m. and returned to the police station at 5 p.m. on 31/12/2023, along with the seized items and apparent person, namely so-and-so, my lord, and handed over the seized drugs to Saristada Ratabari PS by Ratabari PS case number so-and-so. It is also to be noted that during interrogation of the driver Mitraful Haq at PS, he revealed that on 31/12/2023 morning, Niarun Nasa, wife of Asaruddin, alias Asari, alias Loli of village so-and-so, gave him the narcotic drugs to deliver it at Anipur area. He also revealed that Asaruddin and Motiur Rahman few days ago brought the narcotics drugs from Mizoram area to sell it at different locations and Kasar and Korimur. This shows, my lord, the contraband which was recovered and seized, my lord, it was brought by, my lord, Asaruddin and Motiur Rahman.
The 20, number 20.
Number 20, my lord. And regarding, my lord, 50, my lord, I have Want to the scan copy of the record, my lord. Yes, the grounds of arrest, my lord, it is mentioned, my lord, as they have used the, my lord, before, my lord, passing on the Vian Kumar judgment, my lord. It is there.
Same, more or less same submission for you. So your submission is more or less same. Your petitioner was not arrested from conscious position.
My lord,
Subsequently, he got arrested as Mr. Borwa read out.
my lord,
So on the basis of the statement of the co-accused and subsequent development
my
was
lord.
there.
On the date of, on the statement of co-accused, I was arrested. On the date of arrest, my lord, nothing was recovered from me except my mobile phone, my lord. And my lord, I also filed the additional affidavit, taking the new ground of, my lord, non-communication of ground of arrest, my lord. And in forwarding report is also, my lord, that is also, my lord, not a contemporaneous document, because in forwarding report, my lord, there is only reason for arrest was there, my lord, not ground of arrest was there, my lord. So I have annexed the similar order of this honorable court giving bail to the co-accused, my lord, on that ground only, my lord. So I also pray for bail, my lord.
You have certified copy?
My lord, I annexed, my lord.
You already annexed in your petition?
In my lord, additional affidavit, my lord. In additional affidavit.
They will on the record also, my lord.
Record is there, otherwise we have the records.
Yes, it is there on the record.
My lord, on page number 65 of additional affidavit, my lord. And bail order of another accused, my lord, Mitraful Hawk, my lord.
Yes, sir, yes. Sir. It's already annexed in my petition.
Page number 65 is the order.
My lord.
And your thing that grounds of arrest, where you have annexed? Your
My
grounds of
lord,
arrest?
on page number 10, page number, my lord, 63 and 64, my lord, of additional affidavit. Notice
63 and 64.
63 and, my lord, 64, my lord.
Yes, yes.
Notice under section 41B and notice under section 50.
Oh.
We are behind the bar for, my lord, for last more than 290 days.
He got arrested on 1/1/2024 and you
My
got
lord.
arrested on?
On the same date, my lord.
Same day.
Same date, my lord. But I was not arrested on the place of occurrence, my lord. I was arrested from my home, my lord, on page number 17. Honorable good, please take it, my lord.
Hard mistake 19 to know, hard Mr. H.R. Chaudhary, Dilani counsel for the petitioner. Also hard Mr. Ajay Bora, I can same takibo. In order arrest policy 1/1/2024. Today, 1 year, 4 months, 4 days. Now, by the way, what is the stage of the case?
One person was absconding, he subsequently he surrendered, my lord, last production.
Charge has been framed?
No.
Not yet.
Charge has not been framed.
Not framed.
Last date was, my lord, 29/3/2024.
Yes, not yet framed.
Though the charge sheet was filed, but due to absconding of one of the accused person, charge could not be framed till date by the prosecution. Same duita submission eke hobo. And the other submission anibo. Take it out that he was the co-passenger of the passenger of the vehicle from which the alleged recovery was made, and he has no relationship with any contraband or contraband or with the other co-accused persons. He was merely arrested as he was traveling in the same vehicle. He can take out assumption, but he more or less same take it. Our arbitration number 2019 on submission board padibo that from conscious position. These were accused from the vehicle, conscious position from the vehicle, along with 2 other co-accused persons from Borwa's vehicle observation. And 20th at Adibo, he was arrested merely on the basis of statement made by the co-accused, and he is no way connected to instances. He also arrested on the same day, that is at 1/1/2024, same time. But nothing has been seized from the conscious position of so and so. Mr. Borwa's submission demo in item number 20 that though there was no conscious person from the accused petitioner, but he is the main kingpin of the entire proceeding and he who brought the contraband, some Manipur, no?
They supplied, yes, ma'am.
Supplied the contraband and that was brought from Manipur along with two other co-accused persons. So he is the main kingpin of the case who was the supplier of the entire drugs of the contraband. He Borwa submission. Arrest same of
My objection may be also be.
yes, yes. And the page number item number 19 not. They have annexed one order of this court on item number 19 at page number 73. More or less same will be there. Okay.
Obliged.
Item number 19 of item number 19 of page number 73. Baki preliminary submission.
Item 21.
Madam, here, madam, the instruction was possibly sought for, madam, whether extended or not, madam.
The extension was made from the IO lordship for seeking extension of judicial custody for Christian which was allowed.
That was allowed.
Allowed. So we have to send back the city to theory investigation. So for further investigation for. Otherwise, sufficient material taken the petitioner at this stage of investigation.
No, on that day we kept it because one petition was filed for extension of
Extension,
period, but
that is
as
allowed.
per your instruction, there is an extension is
Extension
there.
allowed.
Now you have perused the case diary, extension may be there, but materials may not be there, whatever. So as per you, have you gone through the case record, case diary?
Should be lordship because we are waiting for the extension. We need some.
Now see, the question is extension is different thing.
Lordship.
Definitely on the period of the some of the case record and all, but case diary, the extension was made. There may be some materials, but I don't know whether there is a materials in the case diary or not. That's what I'm asking.
My lord, can I pray one thing?
Yes.
To make it short, my lord, because here possibly my lord, with my limited understanding, my lord, that section 47 notice we have annexed, my lord. It is not substantial compliance. Lordship, kindly, then it will be possibly easier, my lord. And regarding 48 also, from the forwarding report, it is apparent non-compliance, absolute non-compliance, my lord. That's why, my lord, it's voluminous, my lord. If that counts, my lord, then possibly, my lord.
I don't know. Yes, Kusami, what do you want to submit?
Can you also kind
Don't I, where do you have annexed?
my
Those
lord,
things?
page 34 is that, my lord, 47, my lord. Other, if you're also not satisfied, then you can go to merit, my lord. Then 34, my lord, there will also find, my lord. The grounds of arrest kindly available.
So 47, there are some compliance.
Not, yes, some, my lord, because the FIR and the forwarding report states about several persons, my lord. My link with one individual in particular. And
No,
that,
but yes, whatever, there are,
yes, yes.
may not be
Some,
specific, may
yes,
not be what, and then what the other
and regarding 48, kindly have a look at that last, my lord, handwritten one, my lord, in that same page, my lord, page 34.
Same page.
Yes, yes. The last line, Lord should see, my lord, handwritten, my lord. WT sent to his local PS to inform about his arrest. Inform
No,
about,
that is the there in the 47 itself. I am asking whether 48 was there or not.
is regarding 48, my lord, possibly, my lord, kindly see, my lord. WT, through WT message only, my lord. And that too to the local police station, my lord. To inform the petitioner, accused petitioner's side, my lord, family. And
Now,
that
the
too-
question is just a true WT message, the message was sent to local police station. But thereafter, whether this was accompanied with any 48,
No, my lord.
how can we say now?
They have to show it, my lord.
They will show it.
Yes,
We are here.
duty message is here, but 48 the notice yet is not in the case there.
Not to show.
No, you have to go through.
Yes.
Have you gone through the entire case record? Because WT message is obviously there, as Chaudhary has submitted, WT was there. But whether the WT accompanied with any 48, that's what.
Allow me some time to go through this. This is a voluminous. Today is not possible. It's another.
Today it not been be possible.
Very voluminous.
Even on merit, all persons, my lord, who were arrested on day one, my lord, they were the dreaded terrorists as per the, my lord, allegation. No, my lord, charge sheet till date, my lord. And all those persons allowed to go on bail statutory, my lord. And here also, my lord, kindly see to detain this person only this, my lord, extension, because till now when charge sheet is not there, So prima facie case possibly is not there till now, till the, so far against the, all the arrested accused person, including the present, and including the persons who are allowed to go on bail. Because if there was a charge sheet, then it was a different thing. That charge sheet has been filed. They have sought for further investigation.
Yes, when it can be. Tomorrow, lots of other matters are also being fixed. I don't know. when.
WT message is there just now.
No. You want to submit only on WT
No, no,
48
no.
or you want to go by the record? That's
Record.
what I'm asking.
We have to go to, I have to go to. the
Only if you
records.
47, 48, then it's okay, you see, and then tell us. And if you only go on to the merit also, you can submit. At least some merit you should submit, I think. And when if tomorrow it will be possible for you, because Mr. Chaudhary's submission is very simple. He is not associated and 48 was not there. Day after tomorrow is a holiday. I won't come.
Tomorrow.
Tomorrow will be possible. Tomorrow, bahut ase nahi matters. How many matters are there?
37 or 40.
No, tomorrow is not possible. Fixed matters are only 25, 30 numbers of fixed matters are there.
47 night, 48 nothing left. If 48 not complied, my lord, then possibly, my lord, you would be entitled, my lord. Let him check up that thing, my lord, if it is there, my lord, or not. Otherwise, without going into the entire diary, my lord, if it is not there, 48, my lord, then
8.
8. List on it, good.
Much obliged, please.
In case of the notice, for this one to.
Notice is returned.
Yes, can we get?
Notice. I don't know.
That information we have not received, my lord.
Last occasion also matter listed next week. Today is fixed for that information only. If they are not, then amicus curiae is to be appointed. Then matter may be.
And we can do one thing. You have already received the witness statement also as per the earlier order. It has already been received.
No, records has come, my lord, but there is one problem, my lord. The PW2 is a victim, my lord. Our evidence is incomplete, my lord. Incomplete, yes. That is why.
Oh.
3 occasions she is remain absent. After giving evidence, her evidence, further evidence reserved, 3 days she is not come, madam. She is avoiding.
But
It is on
whatever
record. It is
her
on record.
evidence is required.
It is on record. It is
Our
order.
evidence will be required.
Sir, my lord.
No,
Evidence?
what I'm saying that
Informant already, informant examined, victim examined partly.
partly in a sense, it is cross-examination left over or the entire evidence of one chief is also.
Chief part
is reserved.
already reserved.
I already finished the.
And charge is also start, my lord. Earlier it was charge frame on 4 of POXO, my lord. Now it was frame on 5M of POXO. 5M.
5M. No, penal section is 6 or what? Yes, aggravated. It will be 6. It will be 6. Category is this one 5M and this penal provision will be on 6.
It is already mentioned in the search, my lord. From the date of arrest, I am in.
Where from you are saying the charge is altered?
So there is a my lord, order, my lord.
When 2312? No.
There's a search frame, my lord, order. Then, my lord, there's another page, my lord. Where it has been reflected, my lord. The charge has been altered, my lord.
It will look.
So, Lordship may kindly peruse on the 25/3/2025 order.
25/3.
I may be wrong, my lord.
Initially 25-3. Twenty-five three is not here.
I don't.
No.
We record this one.
We have till last order as per 5-3 only. 25-3 one saying.
Silent.
Anyway, Mr. Borwa, can we appoint one amicus today because it is a POXO matter she is waiting. Otherwise,
that
we
can
don't
be
have.
done, my lord.
But my lord, she's every time got information, my client informed me, she'll not never come here. She will everything. That is why she's 3 times she's not come to the court to complete her evidence, my lord.
But I'm sorry, 27-3, my lord.
Acha.
27.
Whatever may be, sir, maybe 6 or I have no any objection in that regard.
So it was 4, then it was 6.
Can it be done without issuing notice, my lord?
Because accused is her relative, in fact. And in view of this, the relationship 4 is not attracted. So 6, there are some criteria. So 5M attracts. That's why it is 6. Okay, then. Heard Mr. G.U. Amit, the learned counsel for the petition. And also heard Mr. R.J. Burwa, so and so. From the office note, it is seen that the service is still awaited. And however, the scanned copy of the LCR along with the witness is already received by this court. Mr. Borwa submitted in this regard that he did not get any, could not contact the police officer police officer in this regard to know the status of the service report of the on respond number 2. Next para, considering the submission made by Mr. J. Ahmed, counsel for the petitioner, let an amicus be appointed to represent the respond number 2. Respond number 2. Accordingly, as on come up, S does go it. Accordingly, Mr. S does is hereby Surajit Das, Surajit Das is hereby appointed as an amicus to represent the respond number 2. The registry will do the needful accordingly. List the matter.
Next week, my lord.
Next week, we don't have any. It is very simple to say next week. Next week, we don't have any date. It can be both basic case will have fixed, whereas in fact it's very problematic for us to do this date. Bis 20 20.
Item 23.
Yes,
May I
22.
please,
Yes.
Lordship, as per last dated on 28-3, Lordship, scan copy has been called for, Lordship.
On the
This is
last occasion?
Last occasion, second bill application, Lordship. Already 3 witness examined, Lordship. Also, there has been phone.
Earlier was rejected.
Yes, Lordship.
We have received the scan copy.
Yes, the scan copy received, my lord. 3 PW examined, my lord, including the victim, my lord. And victim is implicated, my lord.
Earlier rejection that you have annexed?
Annexure E, page 29, Lordship.
Annexure E, page 39.
29, Lordship.
29.
Yes, Lordship.
So your petitioner is behind the bar since when?
On 15/10/2024, more or less than 180 days, Lordship.
On 15/10/24.
Yes, Lordship.
Acha. Otherwise, there is the implications.
Victim examination.
Victim was how many years old?
She is major.
Major?
She is not minor.
She is not minor.
Sections, POCSO is not added. That is why.
Oh, POCSO is not added
Not
here.
added.
Oh. Heard Mr.
P. Sharma.
Heard Mr. P. Sharma, the learned counsel for the petition, and also heard Mr. R.J. Borua, the learned additional PP, appearing on behalf of state respondent. This is an
In
application.
the search, my lord, her age was recorded at 18 years, 4 months.
18 years.
Page number 24.
Of the hull of Mr. R.J. Borua, the learned additional PP, appearing on behalf of state respondent. And this is an application on section so and so in connection with so and so. Case record received. Scan copy of the case record received. Where is received? It is submitted by Mr. Sharma that the present petitioner is innocent and he has not committed any such offense as alleged in the FIR. However, he is in custody since last 15/10/2024 and the 15/10/24 and his earlier bail petition was rejected on 20/01/2025 in BA number 3759/2024. Considering the fact that the victim was not examined at the relevant time of passing the order at the time of passing the order, full stop. But as per to his instructions, already 3 witnesses has been examined by the prosecution, including the victim of this case. Mr. Sharma further submitted that the accused, being the permanent resident of his address locality, will contest the case and will appear before the learned trial court below on each and every date to be fixed by the court. Next, Mr. Borua, the learned additional PP, submitted in this regard that it is a fact that 3 witnesses were already been examined by the prosecution and the victim was a major at the time of incident. However, the victim which was examined by the prosecution had brought sufficient incriminating materials against the present petitioner, and there may be probability of hampering with the other witnesses of the prosecution if the accused is allowed to go on bail at this stage. Next paragraph. Considering the interest submission made by learned counsel for both sides, and also considering the fact that the victim has already been examined by the prosecution, and hence there may not be any probability of hampering or tampering with the vital witnesses of the prosecution, vis-a-vis considering the length of detention already undergone by the accused petitioner. I do not find that further custodial detention is required for the present petition. Find it is wherein case is pending in which district?
West Karbi Anglong, Hamren.
West Karbi Anglong, Hamren means Diffu.
Yes, Lordship.
Diffu or no. It's a Diffu or go?
The district of Karbi Anglong.
Karbi Anglong.
Yes, Lordship.
Karbi Anglong
Court
means
of,
special judge?
Session Judge West Karbi Anglong, Hamren, my lord. Case
Session
number
judge
34.
West Karbi Anglong, Hamren.
yes, Lordship.
Dissection of the session judge West Karbi Anglong.
Special Judge, Lordship.
Special judge West Kamren.
West Karbi Anglong, Hamren.
Hamren.
Special Judge.
Okay, special judge West Karbi, Hamren.
Wait, please, Lordship. This is item number 47, Lordship. FIR and PD of FIR crossover will call for.
All this after delivery, I'll put my signature in the chamber. This are reading. Signature will be done. Attack date. Bail petition is allowed. And your petitioner is allowed to go on bail for rupees 50,000 with 2 securities of the like amount to the satisfaction of Swens.
Item 2.
He also bail petition is allowed and to the satisfaction of learned special judge Kamrup Amin Khan, you have to file your bail bond.
Supplementary list, delivery of order, item 41.
Here also bail is granted to the satisfaction of special judge Kamrup Amin.
Obliged.
Item 42.
There are also 2 petitioners are there, they are allowed to go on bail.
Item 43.
Keep your light, man.
Same here, petition is granted. Bail is granted.
44.
Here is also bail is granted to the satisfaction of learned special judge. Yeah, sure.
Very busy, Lordship. That's why item 47, case diaries of both the main FIR as well as the cross FIR were called for, Lordship. The case diaries have been received. Lanesh has informed me that they are not up to date, Lordship. Perhaps, Lordship.
After 7 year case I received long time back, my lord. Subsequently, my lord, due to some reason or other, the case was not taken, my lord. It is due to adjournment, my lord, and CD remain here, my lord, because we are asked to keep the CD, my lord. So now the last update is from the month of February.
Last entry was.
Perhaps the updated CD, my lord. In both the cases.
47 and
47.
My lord,
here 47 2 matters are there.
47 FIR of main CD of main FIR as well as the cross FIR.
For both the
CD.
CDs. Mr. Gupta is appearing for respond number informant. Here, is there any interim order? No.
Lordship may kindly fix it on 21st May.
Heard Mr. N. Hassan, the learned counsel for the petition. And also heard Mr. R.R. Kaushik, the learned additional PP appearing on behalf of said respondent.
26.
It is submitted by Mr. Kaushik that the last entry of the case diary in both the case number, in both the case number sound? Case number,
Dumduma PS case number 7/2025.
Dumduma.
Yes.
One is Dumduma PS case number 7/2025. 25 and other
is 8/25. 2020.
Again, it to Dumduma PS case number 8/2020. Also heard Mr. A.K. Gupta, the learned counsel appearing for the informant. Let the CDP return calling for updated one. Yes, he is seeking 21. Can it be?
On 26.
26, okay. Let the CDP again call for 26. 26, right?
Oblige, Lordship.
Bail is bail hearing, item 24.
Please, your lordship.
Yes.
In this case, the last occasion case area was called for, lordship.
Charges submitted here.
Lordship, although charges have been submitted, lordship, we filed the additional affidavit, lordship, showing non-compliance of section 47 of the BNSS.
You take those grounds before the learning trial.
Lordship, in the, as your lordship aware, the recent judgment Bihan Kumar, lordship.
Definitely, we were aware of.
There,
14 days
there
been
is a
discussed.
there
I
is a-
just told you that as the case has been charge sheeted, we do not want to interfere. You can.
There it was,
appear.
lordship, held that the.
It was held. We have the knowledge.
Filing of the charges would not
Even if the
immediate,
filing of the
breach
child sheet, the case is entertained. We
Yes.
can understand. But I'm saying that as the case has been charge sheeted, you may approach the learning trial with the same fear.
There will be a lordship after recording of the witness of the victim, bail will be considered. That is generally happens nowadays, lordship. Now in the merit also, I have a very good case, lordship. The allegation.
No. Question is different. Question is that as case has already been charge sheeted, that is why we are saying on that ground only. That if this charge sheeted case is charge sheeted, you can approach the learned trial court below with the same prayer. Because it is a charge sheeted, generally we do not want to interfere. That is the main issue. Otherwise, we are interfering. All the charge sheeted cases are all before us. At the case of evidence, we are dealing with the cases. There are cases, we are dealing with the
Yes,
cases.
because
And
it-
even if, as you have submitted, Vihan Kumar is very specific to that, even if we charge sheeted cases, that
That's why
that
they are
principle
being,
is applicable.
that's why they are being a statutory requirements.
Yes, everything is there. So
Lordship,
you have to appear.
Lordship, because why I am pressing, lordship, the petition is a 19 years old tender boy's, lordship, and
Know what to do.
allegations against the boy, against a boy, lordship, by the boy, lordship.
He should not do all these things. He should
All are
not- he should
minor,
not-
they went for swimming, lordship, and someone videographed the swimming process and thereafter published
Yes,
it on
I
the
know.
Facebook.
I have gone through the FIR 2-3 times, I think.
Then lordship, with some observation that I have filed this additional affidavit, taking the non-compliance of section 47, lordship, maybe.
Yes, some.
Otherwise, charges submitted.
What is this CS number?
Number 64/25.
64/25.
19/4/25.
19/4/25. Okay, go to heard Mr.
B. Haldar.
B. Haldar, sorry. B. Haldar, the counsel for the petition. Also heard Mr. R.R. Kaushik, the learned additional people appearing on behalf of state respondent. Case was fixed for the case diary, but it is submitted by Mr. Kaushik. That case has already been charge sheeted by CS number 64/2025, dated 19/4/2025. In that context, Mr. Haldar, the learned counsel for the petition, submitted that there are some good grounds for bail, and he also raised the issue of non-furnishing of the non-furnishing of the ground of arrest in the notices under section 47 and 48 of the BNSS. Mr. Haldar is accordingly, petitioner is accordingly hereby directed to appear before the learned trial court below, and will be at liberty to take the grounds of non-intimating the and liberty to take the ground of non-intimating the grounds of arrest in the notices issued under section 47 and 48 of the BNSS. With the above direction, the present petition is dismissed. Okay. We have a direction, you have already intimated that 47, 48, you can be at liberty to take.
Obliged.
Item 25.
My lord, in fact,
Here you have filed your objection and.
Yes.
You have already filed.
Yes. My lord,
Okay,
this
so
is,
scan copy is also called for loss.
it is
Yes,
there.
no, so second copy too. Scan copy was there. Scan copy was called for, it has not been received, I think, I know, it's not
Definitely not
received.
received.
My lord, just a second.
Scan copy of driver has not been received yet.
We have still awaited.
Whereas written objection filed by the respondent has.
Your written objection is already there.
My lord, in my respectful submission, my lord, he's written the documents which he have annexed in his written objection, in my understanding, my lord, will be sufficient for this bail, because my primary ground is that the grounds of arrest has not been intimated. And your lordship has today decided, my lord, because the other day your lordship said that your lordship will be deciding the cases. And today morning, to just few minutes before, my lord, your lordship has already, my lord, this is a cover case, my lord. The grounds of arrest, my lord, may kindly take up their objection. I'll submit from their objection itself.
Yes.
My lord, may kindly come to page number 78, running page of their objection. I mean, that is the pagination available in my copy, my lord, page 78. My lord.
78 is your.
78, that is what I am served with a copy of their objection, which has been paginated at page 78.
78 is a notice.
Yes.
Oh, yes, yes.
Yes. 78, my lord, your lordship has seen this, my lord. And my lord, another additional document is at page 77. That is the memorandum of arrest. My lord, the memorandum of arrest nowhere states about the ground of arrest. Nowhere. And this memorandum of arrest, my lord, in 4 cases, 2 passed by your lordship, 1 by the coordinate bench of Justice Goswami, and the other by a coordinate bench of Justice Kolita. They have also, my lord, while this memorandum, because NCB has the same format, my lord, while this memorandum, similar memorandum of arrest was pressed for to show some compliance, but the court have, my lord, declined that this is no compliance of Article 22, sub-article 1. Because, my lord, it simply says section 8C. My lord, I'll just read it for a while, my lord. In consequence of connection with the recovery and seizure of methamphetamine tablet 7.198 kg from Hyundai Accent car, bearing registration number such and such under section 42 such and such as amended such and such, hours near Sonapur toll gate such and such. I do hereby arrest Babla Mia, that is me, son of such and such, resident of such and such, under section 42, only sections 42 of NDPS Act as amended at such and such at the office of NCB Guwahati on reasonable belief, prima facie proof that the seized goods, article, documents are liable to confiscation under section 60 and 61 of the NDPS Act, and the aforesaid Babla Mia is liable to proceeding under section 8C, read with 22C. It does not say, my lord, what he has done. My lord, 8C, my lord, even I have some experience of dealing with the NDPS Act. Even if somebody asks me that what is section 8C, I won't be able to say. Section 8C deals with 15 types of offense. 15, my lord, may kindly see section 8C. What he has done? What is the imputation against me? Section NDPS Act to the kindly see section 8C. My lord is there at it.
Yes.
My lord will see. No person shall, that's the opening line, C, produce, manufacture, possess, sell, purchase, transport, warehouse, use, consume. There are 15 types of things. Now, I am implicated for doing what? For producing, manufacturing, using, importing, exporting. And my lord, I will not trouble your lordship much. This was dealt by our High Court. This arrest memo, I'll give Justice Kolita judgment to the Justice Kolita judgment. Yes, this is the judgment. Already dealt and decided that this is no compliance. My lord, may kindly come to paragraph
the Honorable Court's finding is that para because this arrest memo was dealt in this case, non-compliance of as regards the plea of yes, para 14, as regards the plea of non-compliance of plea of not furnishing the grounds of arrest is concerned, Mr. S.C. Khayal, the learned standing counsel, DRI submits that in the instant case arrest memo which was served on the petitioner and which the petitioner received after putting his signature thereon contains the grounds of arrest as well as the facts which necessitated his arrest. He also submit that the petitioner, I have considered the submission made by the learned counsel. In the present case, the petitioner has taken two grounds for seeking bail: non-compliance of constitutional mandate, and the ground for bail taken by the petition is that of prolonged incarceration. My lord, about non-compliance, yes, para 20. In the instant case, para 20, my lord. In the instant case, though the arrest memo mentions about the recovery of seized contraband from the truck bearing registration number such and such, however, in the arrest memo, it has not been stated that the said truck was driven by the petitioner or that he was present in the said truck. Para 21. In the present case, the arrest memo labels an accusation against the present petitioner contravening the provision of 8C of the NDPS Act 1985. However, it is not specifically stated therein as to in what manner the said provision were contravened. Thus, though some facts were stated in the arrest memo furnished to the present petitioner in the instant case, however, it is cryptic in nature and no clear accusation narrating the basic facts necessitating the arrest of the petitioner in the instant case has been mentioned in the arrest memo. Same arrest memo. And your lordship's order, my lord, this is NCB, Pramod Kumar, or Pramod Kumar, or Gurvinder Singh Malaki, Justice Nandi. And another, your lordship, and Justice Nandi. Same, because in NCB cases, they maintain the same type of document. This arrest memo, where simply they say some sections 42 and no accusations. These are also NCB cases where similar arrest memos were there. One by your lordship and the one is by Justice Malashi Nandi. And they last week, even Justice Goswami gave an order of same arrest memo NCB. The same counsel was also appearing. Did they take it? Justice Goswami? And today also I have seen in delivery of orders, there was one item versus NCB. In that case also, because they maintain the same sort of arrest memo. These are the two. This is my case, my lord. Other will do. And the length of detention and everything in a small piece of paper I have already given, my lord. So when arrested and all this. This is my case.
Section 50 CRPC. What mandates and what required to be given to the person while arresting?
Yes.
It says that person arrested to be informed of the ground of arrest and right to bail. One, every police officer or other officer arresting any person without warrant shall communicate him full particulars of offences for which he is arrested or other grounds for such arrest. Particular of the offences for which he is arrested or other ground for such arrest if he is not arrested. Lordship has seen page 178 and section 50.
Yes.
First name is there, then his details are given, then case number. Under section, you are hereby informed that you are arrested in connection with the above reference case, and case is not available. So you are forwarded to the court. You may submit petition before the honorable court for your bail. Then signature of arrestee, then he put his signature in English. Now, Lordship, ground of arrest memo. I am again reading, Lordship. Whether any deviation is of the section is there or not. May kindly to see. Arrest memo. In consequence of connection with the recovery of seized methamphetamine tablet of 7.198 kg from Hyundai car bearing registration number so and so under section 42 of the NDPS Act on 2012-2023 at 5 hours near Sonapur toll gate number so and so Nisra Khat, Assam. I do hereby arrest Mia, name is there. Then under section 42 of the Narcotics Substance Act at 19 hours at the office of the Narcotic Control Bureau, Assam, on reasonable belief and prima facie proof that seized goods, articles, documents are liable to be confiscated under section 60 and 61 of the NDPS Act. As aforesaid, Babulu Mia is liable to be proceedings under section 8C2 read with section 22C of NDPS Act for contravention of the provision of narcotic NDPS Act, which have already been duly explained to him or her. The aforesaid arrest person is being forwarded to so and so. Then lordship below, he put his signature, date is also given. Then his this intimation of arrest has been given to his wife Sabana Yasmin at her mobile number so and so. Then he put his signature. In section 50A, obligation of person making arrest to inform about arrest, etc. to a nominated person. Then lordship, page 79. Intimation to his wife. Dated 23rd December 23. Name of the wife of the petitioner is given. Intimation of arrest regarding this is to inform you that on 22nd 23, Narcotic Control Bureau, Guwahati has seized methamphetamine tablet of 7.19 kg from Hyundai car, bearing registration number so near Sonapur, so. The case is in this regard has been registered under section 8C, 22C and 29 of the NDPS Act, crime number so. Further, you or husband, namely Babulu Mia, has been arrested on 23/12 by investigating officer NCB Guwahati in connection with the case. Now, lordship may come to page 22 of the bail application, page 14. The averment of the petitioner in the bail application.
Page 20.
No, sir, lordship, this is a final complaint. That's please to see the statement given by the petitioner.
Page number, yes, sir.
And page 6.
6.
Paragraph 29.
Yes.
Lordship, I'm sorry, lordship, page 4, paragraph 5. That is a part of the judgment. That the petitioner begged to state that ground of arrest were never communicated to the petitioner, nor or to his relatives, which is evident from the bare perusal of notice issued under section 50 of the CRPC. It is submitted that the notice under section 50 of the CRPC does not contain any ground of arrest, which is not the requirement of the law also. The notice under section 50 CRPC is a printed format where there is no column indicating ground of arrest. The petitioner begged to state that the arresting authority had violated the provision of section 50A of the Code of Criminal Procedure corresponding to section 47-48 of BNSS, which resulted in violation of provision of fundamental rights granted under Article 22(1) and 22(21) of the Constitution of India, thereby making arrest illegal. The next lordship judgment has been referred. So this is a false statement, lordship. We have produced the document, lordship, and I have read out the section 50 and 50A, where lordship we have meticulously complied with all the provision of the law. And the ground of the arrest memo, it contains all the provision of law and other things. And regarding lordship, he was arrested on 23rd December 23. The final complaint was filed on 12/6/2024. The login condition will not come into play in this case. And regarding the complaints of the provision of section 50 and 58, it is there. I produced before your lordship by filing objection. So in the section second lordship, the petition is in that integrity, considering the object of the purpose of the act also.
Two quick response to the submissions made. Probably, my lord,
the counsel for the NCP is confusing with ground of arrest and intimation of arrest. Your lordship has read the judgments, my lord, I need not take your lordship. That is an intimation of arrest. Intimation of arrest and grounds of arrest are different. My lord, the argument which has been made is also covered by Rehan Kumar, where, my lord, it has been specifically said that the requirement of Article 22(1) is in addition to the requirement of Section 50. It is in addition of Section 50. Because otherwise, if Section 50 has the potentiality to override 22(1), then by virtue of Article 13, Section 50 will be ultra vires. Because no law, any law which tries to infringe fundamental right is void ab initio. In categorical terms, my lord, Supreme Court has said that the requirement of Article 22(1) is in addition to the requirement of 51. Should I take your lordship has read it? Your lordship has read it. This is one. And these are mere intimation of arrest. These are no ground of arrest. Some sections are being thrown at a man, my lord, and he's expected to know Section 8C, 42, 43, and all these things, my lord. So, my lord, this is my submission. And the statement which I have made at para 6, I stand by those statements. There I have categorically said the ground of arrest. I have not said intimation of arrest. If I would have said that no intimation was given, then that would have been a wrong statement. I said no grounds of arrest has been communicated. These are the two. And my lord, already, my lord, these submissions were made before a coordinate bench of this court, my lord. This was dealt, my lord. If they need any change in that observation, in my limited understanding, probably they will have to move to a higher forum. Because already this has been dealt by this Honorable High Court. This has been dealt, my lord. So now, probably, my lord, in my limited understanding, there is no scope of even arguing otherwise. Because this has already been dealt and settled. I have showed your lordship this. And not only one coordinate bench, but by multiple coordinate benches have dealt with that. That's my understanding, my lord. And intimation of error, Section 50 cannot override 22(1). 22(1) is clear. There is no ambiguity. In fact, my lord, today morning when this matter was listed, I was under impression that I'll have to argue on that conscious possession, and I bought all those judgments also. But since your lordship has already delivered the judgment of conscious possession, therefore I'll not take your lordship to all those things. That's my answer. I'm grateful.
Otherwise, here also, as per allegation, the conscious possession is there.
My lord,
as per allegation, what I'm saying, methamphetamine tablets were recovered from his
No, my lord, as per allegation, the correct fact is this. As per allegation, there were 5 persons in a car. One was driving and the other was co-driver. I am neither the driver nor the co-driver. The methamphetamines were found from a bag which was kept inside the driver's seat. I was sitting, it is not a case where something was recovered from my pocket or from my bag or something I was carrying. So, my lord, those are, it is from a separate place, not attached to his body or anything of that sort.
Then lordship, in this case, lordship, Nawaz Khan's judgment will be applicable.
Nawaz Khan.
Lordship, with regard to conscious position, and if anything has been recovered from the conscious position, that judgment has been reserved on the Supreme Court, whether compliance of providing a ground of arrest is necessary or not. Probably within this week, judgment will come.
My lord, I will not make submissions on that, my lord, because I also came prepared to make submissions on that. My lord, that is a equal bench has been constituted, and that the issue before that Oakley hit and run case is different. It says about whether it has to be complied immediately or delayed compliance will be required. My lord, what I can sense from the argument made before the Supreme Court, probably some window they will give in cases where it has been red-handed, or in those cases, probably a 24 hours time or 48, something of that nature will come. But completely dispense with fundamental right under Part 3, Article 22, there is a far cry. That even the Supreme Court will also not do. And even if they intend to do it, then a larger bench has to be constituted. And my lord, those would be submissions in speculations. What a court will decide, my lord, probably it will not be fair on my part to even make a submission what honorable court will decide at a future point of time. So I'll not go into all these things. and these are coordinated by already those submissions were made, my lord. Because the entire, I'm told that additional public prosecutor, Mr. Rishi has argued about that based on one that MP, Bihar MP case. What was his name? Madhulimai case. My lord, I have read Madhulimai case also. In Madhulimai also, he was caught red-handed. That man has violated the prohibitory order under 144 just beneath the nose of the magistrate and police. Magistrate and police were standing and he have violated it with 100 people. He have made that protest. Supreme Court given him protection. Supreme Court given him protection.
No, Mr. Kaushik has raised the issue that the issue of court rendered was first, raised before in the case of Madhulimai. But however, subsequently it was considered and the bail was granted. Considering the violation of 22(1, that was there.
Yes, it was granted. I am deeply obliged.
So you are submitting on Mr. Nawaz Khan.
Yes. Those are not on the grounds of arrest, man. Nawaz Khan.
This is with regard to position. I'm not submitted that is ground of arrest. I'm submitting on the.
This is from conscious
position. Lordship is to see the purpose of the act and all these things, whether it is applicable or not. This is Muhammad Sami.
And it is.
Dictation in chamber.
It is not going to be listed again.
No, disposal.
Supplementary list, item 45. Disposed of the data.
Yes.
After some time, well, other players gone through, but after some time.
Who is dealing with?
Other proceedings.
Acha. For some time.
Item 46.
46. Item time being the whole
45.
timing to 45 minutes. Oh, sorry. Timing is 45 minutes. No, 46. 46. What is the position? 46. Just a office notice there. It is also bill NDPS matter. Same or POXO matter.
That I won't go through.
Oh, acha, so I will see. Otherwise, we have received this scan copy.
My lord.
Yes, commercial matter. Commercial quantity matter. Six none appears on call for the petition. A scan copy of the LCN has already been received. List the matter accordingly after 1 week, as on a date to fixed by the registry.
Hearing item 26.
May I please, your lordship?
Yes.
Lordship, in this case, the petitioner is on interim, lordship, and up to
Case diary not received.
case diary was called for, lordship.
It is not received.
No, up to date case
After
diary
that,
was
they call
called for.
for, after that, not received.
The last
Not
entry,
received.
last entry is of 2/12/2024, lordship.
Acha.
As per the last order, lordship, 21 to 25.
Yes. You are Mr. Chauhan.
MP Mojumdar, lordship.
MP Mojumdar. Heard Mr. P. Mojumdar, the learned counsel for the petition. Also heard Mr. R.G. Bora, the learned additional people appearing on behalf of state respondent. Updated case diary is not received. Issue reminder. When it can be listed? List accordingly on 26/5/2025. Till then, the interim be extended.
Obliged, lordship.
Item 27.
Lordship, last occasion, Lordship, CD was called for, Lordship.
Case diary not received, but
You are on interim.
Lordship, I am on interim, Lordship.
CD not received. Issue reminder. 26/5 can be given. 20,
My lord, 26.
26, based on 26/5, 2025. Interim be extended till next date of listing.
DPL one.
Item 28.
Here we have received the case diary.
In this case, interim was there, he already appeared. Petitioner is a block development officer, my lord. And a lady, married lady,
এইমাত্র চেম্বাৰত দিম বুলি যে কৈছিলো petition তাতে এইটো পাৰে। Yes. So he appeared.
yeah, appeared. A married lady filed a case, my lord. Maybe some FIRs, but she is having a child. She went to Hojai from district, another district from Bangaigaon. She stayed there. Subsequently, the case was filed when husband came to know that there is some FIRs with them, my lord. Your logical page 11 is the FIR.
No, FIR is against her or her husband.
No, no, not against her husband. Against the present petitioner who is not husband, my lord, who is an officer.
Acha.
Page 11, your lordship, page 11. One year back, your lordship got it, man. FIR is 22/11/24. 1 year back, about when the below named accused was working as a BDO at Vidyapur, I was introduced with him when I went for my ration card purpose and took my mobile number. Accused used to allure me in various ways and proposed to me for a love affair. Accused is presently posted at Hojai. For last few days, accused enticed me over phone to give a job and told me to come to Hojai. On 13/11/24, I kept a minor child in my parental house and by telling my husband's family that I would visit my friend's house at Nagaon. She is saying, well, went to Nagaon and contacted accused, who then took me in the car from Nagaon to his official quarter, where I was confined for about 2 days, possibly so and so. Thereafter, he dropped me at Nagaon, although I came to my husband's house, but due to the recording of some scene of my rape, he made it viral in the social media due to which honor my husband and our family is harmed. Honor is harmed. This is the case.
We have received the case, my lord, 183 statement, my lord, yes. My lord, what is there, it is, my lord, same in the FIR, my lord. They are known to each other, my lord, from last 1 year, my lord, and she went there, she stayed there for 2 days, my lord, but that sexual intercourse with forcefully, my lord, that is the specific line is there.
Part Mr. H.R. Chaudhary, the learned senior advocate, assisted by Mr. Ayu Chaudhary, the counsel for the petitioner. And also have Mr. R.J. Bora, the learned additional VP, appearing on behalf of state respondent. This is an application under section so and so, intention of so and so. CD received, parents received. Next one. It is submitted by Mr. Chaudhary, the learned counsel for the petitioner, that false and concocted allegations has been brought against the present petitioner. Only on the grudge against her husband. However, after obtaining the order of interim arrest bill, the accused petitioner appeared before the IO, cooperated in the investigation, and his statement is also recorded under section 183 BNSS. He is further still ready and willing to cooperate the IO in further investigation of this case if his interim bail is hereby made absolute. Next paragraph, Mr. Burwa, the learned additional PP, submitted in this regard that the accused petitioner appeared before the IO and cooperated in the investigation, but the victim informant brought sufficient incriminating materials against the present accused petitioner, claiming that he had forcible sexual intercourse with her. Next one, considering the entire facts and circumstances of this case, conduct of the accused petitioner, and other aspects of the case, I find that custodial interrogation may not be necessary in the present case, and accordingly, I find it a fit case to extend the privilege of pre-arrest bail to the present petitioner. Poster. Hence, the order of interim bail dated 29/11/2024 is hereby made absolute with same terms and conditions. Your petition.
Item 30.
Disposed.
Case diary not received today.
Here, are you on interim?
Yes, Lord.
CD not received.
No.
CD not received, issue reminder. Yes, when it can be
23/5.
23/5, based on 23/5,
Item 31.
23/5, CD, I mean, the interim be extended till next date of listing.
Hello.
In that case, that paragraph number is 19, Rehan Kumar's 19 number. That 22 requirement is in addition to 50, that is there are 19 of that.
31 case diary not received, my lord. Accused is on interim.
You are on interim. CD not received, same order, issue reminder. When it can be listed,
28/5, man.
28/5. Interim be extended till next date of listing.
May I please, Your Lordship? Well, petitioner want to not press this case, my lord.
You do not want to press
My
it.
lord.
The service report is not complete, man.
No, he doesn't want to press it.
No.
You are Mr.
M. Islam.
M. Islam. Heard Mr. M. Islam, in counsel for the petition and submitted that as per instructions of his client, he does not want to press the petition and accordingly prays for the withdrawal of the same. Prayer allowed, disposed of on withdrawal.
Highly obliged, Your Lordship.
Item 33.
May I please, Your Lordship?
Yes.
This is a this is a previous bail application, Lordship, and earlier interim was granted, Lordship. The petitioner is the younger brother of the FIR accused number 1, and there is the relation with the accused number 1 and the informant, Lordship, and subsequently, Lordship, and he is implicated only, Lordship. You kindly come to page number 13, FIR. Page number 13, Lordship, FIR. And Lordship, last 3-4 lines. In this regard, I made complaint to the family member of the accused number 1. In this regard, the accused number 2 used filthy language and review as, and if I file any case before the police for whom he threats and asks that so and so. Only that must, Lordship, against me, Lordship.
No, the 183 statement, my lord, she has not made any allegation against this and the brother of the accused, main accused person, my lord. Only, my lord, she has made allegation, my lord, that Junaidul Islam, brother of the Ubaidur Rahman, abused the complainant with slang words and pretend to assault her. He has appeared statement accorded.
Heard Mr. F. Oak, the learned counsel for the petition, and also heard Mr. R.J. Purva, the learned additional PP appearing on behalf of said respondent. This is an application, section so and so, in connection with so and so. CD received, where is the same? Post of it is submitted by Mr. Hawk that the present accused petitioner is innocent and he is no way connected in the alleged offense. More so, there is no allegation brought against him in the FIR also. Stop. However, after obtaining the order of interim pre-arrest bail, he appeared before the IO and cooperated in the investigation. Next prayer, Mr. Borwa, the learned additional PP also submitted that the petitioner is extending his cooperation in the investigation of this case and considering the materials in the case diary, his prayer may be considered. Next prayer, hearing the submission made by learned counsel for both sides and materials in the case record, vis-a-vis the conduct of the accused petitioner. I find that custodial interrogation may not be required for the interest of the investigation. Accordingly, the order of interim pre-arrest bail dated 7/3/2025 is hereby made absolute with same terms and conditions.
Deeply obliged.
Item 34.
May I please, Your Lordship? Lordship,
Here we received this case diary.
Lordship, this case is totally outcome of from a land dispute, Lordship.
Huh?
Between
This is a land dispute.
Lordship, between two parties, Lordship. The complainant husband and the petition number 1, they are the cousin, Lordship. Lordship, FIR is page number, Lordship, 12, Lordship. Particularly is page number 17, Lordship. May I read? May I read?
Yes.
বিচারপতি মহামান্য আদালতত ফৈরাদীর সন্মানপূর্বক বিনীত নিবেদন এই যে ফৈরাদীর স্বামীয়ে 1 নং আসামিৰ বিৰুদ্ধে মাটি বাৰী সংক্ৰান্তীয় বিষয় লৈ দেৱানী গোচৰৰ আদালতত চলি থকা আখেজত আৰু ফৈৰাদীয়ে স্বামী ঘৰত নথকাৰ সুযোগ লৈ 1 নং আৰু 2 নং আসামিৰ পূৰ্বৰ পৰিকল্পিতভাৱে অসৎ উদ্দেশ্য ফৈৰাদীয়ে ইংৰাজী 5/1/2025 তাৰিখে সন্ধিয়া প্ৰায় 6 মান বজাত গোহালিত গৰু বন্ধাৰ সময়ত ফৈৰাদীৰ নাবালিকা ছোৱালী সোয়েঞ্চো জন্ম তাৰিখ ঘৰত অকলে পঢ়ি থকাৰ সময়ত 1 নং আৰু 2 নং আসামীয়ে অনাধিকাৰৰ প্ৰৱেশ কৰে আৰু 1 নং আসামীয়ে 2 নং আসামীৰ সহযোগত ফৈৰাদীৰ উক্ত ছোৱালী আসামীৰ ডিঙিত থকা গামোচাৰে মুখত খোপা মাৰি ধৰি ডেগাৰৰ ভয় দেখুৱাই ফৈৰাদীৰ ছোৱালীৰ উৎসাৰ বিৰুদ্ধে FIR is lodged by the wife of the petitioner number 1, Lordship, against the husband of the complainant, Lordship. Lordship, this is the real incident that was happened on that day. Lordship, after knowing the lodging of this FIR, Lordship, the wife of the accused number 1, who is lodged by the wife of the petitioner number 1, Lordship, they make a story and lodge that FIR after 5 days of 10 days of incident, Lordship, LS incident, Lordship, before the CDM, Lordship, Morigaon. Lordship, this is a totally false case, Lordship.
CDM Morigaon 10 days, but they brought with a explanation that they earlier filed a petition, or sorry, FIR before the OC concern, but it was not registered, not investigated. That's why they had to appear before the learned court. There was an explanation why after 10 days was there.
Firstly, we have lodged an FIR with the OC, Godavari police station.
At present, we cannot say because as per their statement made in the complaint, they already appeared, but their case was not registered. So subsequently, they had to appear before the trial court. That is there. That is the as per the. And you have said that you have filed this petition. What I mean FIR. What was the allegation against?
Lordship, that is in page number 32, Lordship.
Yes. What is the allegation?
May I read, Lordship? Respected sir, with you.
Dispute.
I humbly submit that around 15 years ago, we purchased 2 katha and 2 lesses of land from accused number 1. Later, due to financial difficulties, we sold the said land through a written deed to our relative Azizul Haq, son of so-and-so, about a month ago.
So this is then brought in the allegation of assault.
Lordship. Yesterday, that is on 4/1/2025, upon learning that the land was officially registered in Azizul Haq's name from my husband's name, today, that is on 5/1/2025 in the morning, the 2 accused persons arrived at the land claiming to build a house. Immediately, the situation at the spot became chaotic. The accused person grabbed my hair, dragged me, and attacked me with sticks, bamboo poles, etc., causing serious injury to my chest, head.
Thus, appearing for the response number 2. This is an application on section so and so in connection with so and so. CD received, payment received. It is submitted by Mr. Amin, the learned counsel for the petitioner, that the false and concocted allegations has been brought against the present petition only due to grudge/dispute between the parties for between the only because of the grudge and the land dispute between the parties, which is also revealed from the FIR itself that there was a dispute, land dispute is going on between the parties. Mr. Amin further submitted that pursuant to that the land dispute, 2-3 civil matters have also been pending between the parties. Mr. Amin further submitted that on day of the incident, there was the petitioner, the informant side arrived at the disputed land with a intention, with a claiming to build a house wherein there was a chaotic situation and subsequently the accused persons, the informant, the husband of the informant and others had grabbed and PP submitted in this regard that there are sufficient implementing materials brought against the accused petitioner in the statement of the victim recorded under section 183 BNSS. Apart from the statement of the victim, the other witnesses also has supported the case of the prosecution, and he also submitted that as per the note of the FIR, the accused petitioner had already absconded, and hence the privilege of pre-arrest bail may not be granted to the accused petitioner, as there is every probability and possibility of threatening as well as hampering or tampering with the investigation if he is provided with the privilege of pre-arrest bail. Next, madam. Mr. Nawaz Learned amicus for the respondent number 2 also submitted that there may be land dispute between the parties, but for the land dispute also the present petitioner may commit such kind of offense, and from the statement made in the FIR, he submitted that it is not at all a fit case to allow the present accused petitioner to grant the privilege of pre-arrest bail to the present accused petitioner. Next para, considering this submission made by learned counsel for both sides, materials available in the case diary, especially the statement made by the victim under section 164 CRPC, and also the conduct of the accused petitioner in regards to conduct of the accused petitioner, whereby they had already threatened the victim vis-a-vis the note of the IO. I do not find it a fit case to extend the privilege of pre-arrest bail to the present accused petitioner. Accordingly, the same stands rejected. Your petition stands rejected.
Lordship, at least petitioner number 2, Lordship, he has not committed any attempt also, Lordship.
Both the petitioner's prayer is rejected.
Obliged.
Item 35.
Disposed of, rejected. CD query.
Madam, this case, your lordship, and your lordship.
The case diary was called for, my lord, he was interim, my lord. But I have perused the case diary, my lord, it is not up to date, my lord. It's up to date because he was likely to appear before the IO, my lord.
He appeared, my lord. Statement.
But your his statement is not available.
Not there, my lord. There is no note also, my lord.
The interim was granted on 4/4. And the last entry?
Last entry, my lord. 10-3, my lord.
8/3.
10-3.
10/3. Then it is not there. As per your instruction, they had already appeared.
Yes.
Biswas is appearing as a amicus.
No, it's for informant.
Appointed.
Informant, my lord. Your lordship was very elaborate by the 4/4/20. Anyway, my lord, if it is not there up to the.
Let the up-to-date case diary come.
Heard Mr. H.R. Chaudhary, the learned senior advocate, assisted by Mr. I.U. Chaudhary, counsel for the petitioner. Then also heard Mr. R.J. Burwa, the learned additional PP, so and also, and Mr. M. Biswas, the learned counsel appearing for the informant of the respondent. It is submitted by Mr. Burwa, that the case diary received, but it is not updated, and the last entry of the CD is on 10/3, 10/3/2025, and the order of interim bail was passed on 4/4/2025, and thus there is no no statement of the present petitioner in the case diary. Next one, Mr. Chaudhary, the learned senior advocate, submitted in this regard that as per his instructions, the petitioner had already appeared before the IO, and their statements are also recorded under section 183 CRPC. Next paragraph, considering this submission with so and so, let the updated case diary be called for when it can be. 27, list term 25. Till then, the interim be extended till next date of listing. Okay.
Item 36.
My
Yes.
pleasure, Lordship. On last occasion, the respondent authorities had stated before the Honorable Court regarding they are going to file a objection or synopsis. So we have been, I have received the copy and we are not filing any reply, but we want to go through the objection. So basically the contentions that have been raised by the respondent
So
authority.
you are going to submit today only?
Yes, yes. Because of the fact that since it is already there, they have only replied to the submissions that have been made in the pleadings taken in the bail application. So we are totally okay and we want to. So basically now what has happened is that in the objection, they have stated regarding that the kindly peruse to page number 43, my lord, of the objection. 4.2. Here they have stated
43, no?
Yeah, page number 43. That is the objection that filed by the respondent authorities in respect of our bail application.
Point number?
4.2, para 4.2.
Ah, yes.
Preliminary investigation, including analysis of GST returns and available data, revealed that the petitioner's firm have prima facie availed ineligible ITC, that is the input tax credit, amounting to approximately rupees 3.42 crores during the relevant financial period. These substantial input tax credit appear to be predominantly based on invoices received from two entities, namely Messrs. Nilima Hardware and Messrs. PS Enterprise. So the figure which they have now ascertained at this stage is 3.42 crores. So it has to be taken into account of the fact that the provisions of this CGSTS says that if the amount goes beyond 5 crore, then it becomes a cognizable and non-bailable offence. And if it is lesser than 5 crores, it is a bailable offence. Then the fact is that they have stated themselves in that objection 4.8, my lord.
Yes. Right.
Page number 45, para 4.8.
Yes.
That statement of Sri Rajkumar Mishra was recorded on 7/4/2025 and on 9/4/2025.
Yes.
May I? That the statement of Sri Rajkumar Mishra was recorded on 7/4/2025 and 9/4/2025 under the provision of Section 70 of the CGST Act 2017. During the statement, Sri Rajkumar Mishra has inter alia stated that. So these are his statements. Now coming to para number 12, my lord. 12. Para number 12 objection, page number 51. In their objection, but they are trying to put across. The last para, the last para 12, the last portion, if I am. The petitioner's personal statement is vital to examine whether this fundamental condition laid down by Honorable Supreme Court for availing input tax credit has been met, especially when suppliers are prima facie fictitious. Granting anticipatory bail at this nascent stage would severely prejudice the investigation into serious allegations. Now, from this particular para, we can assume that he's yet to record his statement. The petitioner's personal statement is vital to examine. Now, it has been examined. If required, if the respondent authorities want to again try to examine him, they can go again by issuing a summon. Now, the fact is that when they have served the summon on the first occasion, and since he had not appeared on the first occasion and appeared through his legal representative, so they are trying to take that particular contention that since it is not permissible under Section 70 that any legal representative or anybody other than the accused who have been summoned, the one who has been summoned, he has to come down and he has to depose as well as to give evidence. Now, based on that particular contention only, they have again raised this particular apprehension that the statement is that the petitioner's statement is vital to examine.
So it is examined, but if I'm not mistaken, they themselves in 4.8, they have stated that his statement has been recorded under section 70. So that has to be taken into account. Now again, in para number 13, page number 53, my lord, in their objection. Para number 13, page number 53. The last portion, page number 53, para number 13. My lord. The petitioner's conduct in avoiding personal appearance under section 70 raises legitimate concerns about his intentions and potential attempts to obfuscate the facts. The petitioner's conduct in avoiding personal appearance, where he has now avoided, he has not avoided, as per the order dated 27/3 and in compliance to Honorable High Court's interim order, he has duly appeared. He is not avoided. Yes, on the first occasion, they can say that he did avoid it, but he had some valid grounds. He was not ill, he was not well, and he had also submitted documents for that. So now again coming back to that particular position that conduct in avoiding personal appearance, he has appeared. He is going to cooperate. He cooperated. He is cooperating. Now what they are mainly concerned is that since this particular offense is relating with other entities also. And now for the information of the Honorable Court, the other entities, which includes that Messrs. PS Enterprise. In PS Enterprise, the prime accused, this Pritam Sobasaria, he is on bail as far as the petitioner is concerned, in his knowledge. And the trial is going to begin. He's charge-sheeted. And already they have also mentioned about the case. Now, since he's already on bail, so there is nothing on this part of this particular this petitioner that no, if he is also allowed on bail, then he's going to hamper or temper. Already charge-sheeted case in that particular Sobasaria case. Now, in his case, they are ascertaining that some amount of 3.42 crore has come after his his statement. Maybe they will require more statements or they will require more examination. So let them do. We are not at all objecting to that. But the fact that they are raising an objection saying that he is avoiding and that we have got reservations on that. And the fact that regarding the citation which they have stated here regarding P. Chidambaram as well as Jagmohan Reddy and P. Ravana Reddy, basically it is regarding economic offense. So in economic offense, pre-arrest bail should be exercised sparingly. Now the fact is that in catena of cases, it is already settled now that pre-arrest bail is also applicable in GST cases. In fact, in Radhika Agarwal, it is already there, as well as in P. Chidambaram case only, they have extracted one portion. There is another portion. For that, I want to place few authorities. So one of the authorities of the High Court of Delhi. So here it has been very wellly discussed, my lord. Regarding the P. Chidambaram fact, the citation which they have placed, my lord, para, that is in Torun Jain versus Directorate General of GST Intelligence. It was pronounced on 26th of November 2021, a bail application, man. So
You have marked it here, para 36.
yes, para 36, that is the first para where it is not regarding the P. Chidambaram, but it has been observed here in para 36. It is stating here, my lord, para 36, page number 19. My lord, there is no embargo under the CGST Act restraining the petitioner from seeking pre-arrest bail. So that particular portion we want to take. And then now coming down to the P. Chidambaram case, my lord. Yes. That is page number 22, para 43. My lord. Yes. Thus, from cumulative perusal of the judgment cited on either side, including the one rendered by the constitution bench of this court, it could be deduced that the basic jurisprudence relating to bail remains the same in as much as the grant of bail is the rule and refusal is the exception, so as to ensure that the accused has the opportunity of securing fair trial. However, while considering the same, the gravity of the offense is an aspect which is required to be kept in view by the court. The gravity for the said purpose will have to be gathered from the facts and circumstances arising in each case. Keeping in view of the consequences that would befall on the society in the cases of financial irregularities, it has been held that even economic offenses would fall under the category of grave offense. And in such circumstances, while considering the application for bail in such matters, the court will have to deal with the same, being sensitive to the nature of allegation made against the accused. One of the circumstances to consider the gravity of the offense is also the term of sentence that is prescribed for the offense the accused is alleged to have committed. Now, here in this particular case, your maximum is up to 5 years. So the gravity of the offense will have to take into account. Now, in PMLA cases, it's more than 5 years. It is only up to 5 years. So that is have to take into account when this pre-arrest bail is taken for here. Such consideration with regard to the gravity of offense is a factor which is in addition to the triple test or the tripod test that would normally be applied. In that regard, what is also to be kept in perspective is that even if the allegation is one of grave economic offense, it is not a rule that bail should be denied in every case, since there is no such bar created in the relevant enactment passed by the legislature, nor does the bail jurisprudence provide so. So we are now countering the fact that since they are saying that it's an economic offense, the fact is that now that offense, the amount at this point of time is 3.42 crore, which is less than 5 crore. It's a bailable offense. The conviction is up to 5 years. And the fact that he is cooperating, he has already recorded his statement. And the fact that if required, he's going to again cooperate. The contention which they have got that he could flee away since he is from Jharkhand and that he could flee away. That's why the conditions that have been imposed by this honorable court has to be complied with. And he's complying. He's currently in Guwahati under the jurisdiction. So even if he wants to go, then he has to take the prior permission of the jurisdictional magistrate. So when everything is at this point of time, when they are ascertaining the total amount, which they are saying that it may increase during the course of investigation. Yes, it may increase. That is a matter to be taken up by the authorities. And if there is any increase also, and if trial is to be conducted, then he is going to come and it is a matter, subject matter to be decided in the trial, how he has been involved and implicated in the offense. Because the offense is 132. Now, if he is going to implicate, it is going to be 132 1C. That means that he has paid money for goods which he has not received. That means someone has not supplied him with the goods, but he has paid some certain amount. So they are deciding on that fact that to what parties he has paid the amount and why they have given the invoices saying that he has paid that amount. So now that is a thing subject matter of trial, which is already being undertaken in case of Pritam Soborsaria case. It is going to be there. So he is there. So he's going to cooperate in the trial. So we don't think so that there is any bar on this particular application to be entertained by this honorable court and to be allowed. So this is our one part of the submission. And then again, coming back regarding para 40 now, my lord, in this particular judgment only, para 40, page number 20. Well, on the other side, the case of Shravan A. Mehra versus Superintendent of Central Tax Anti-Evasion Commissionerate, there is a, I think the citation number is the one that squarely applies to the present case. In this matter, bail was granted in relation to offences under the Act in view of the fact that the offences were not punishable with imprisonment more than 5 years. In this case, the petitioner was alleged of having obtained invoices from company of the respondent without delivery of the goods, and thereby evading payment of tax and committing an offence under section 132 1B of the Act. Therein, the petitioner once appeared before the authorities concerned, but on a subsequent summon, they were apprehending arrest because another witness who was called to tender statement was arrested by the police. Thus, an application for anticipatory bail was filed before the court. The court, after analyzing the provision of the Act, held as under On close reading of the above said sections, the maximum punishment provided under Act 5 years, and if that is taken into consider magnitude of the alleged offence and it is not punishable with death or imprisonment for life, even as per the said provision, the alleged offence is also compoundable with the authority who has initiated the said proceedings. The only consideration which the court has to consider while releasing the petitioner on anticipatory bail is that whether the petitioner can be secured for the purpose of investigation or for the purpose of trial. Under such circumstances, I feel that by imposing stringent conditions, if the petitioners are ordered to be released on anticipatory bail, it would meet the ends of justice. So already conditions are already there. And if Honorable High Court is pleased to put more conditions, then the petition is ready. So this particular judgment that has been given in the case of Torun Jain, so it very well it discussed with the nitty-gritties of whether a pre-arrest bail application should be entertained or not at this stage of investigation in a GST case. Then comes the other judgment of the Radhika Agarwal. There it says in Gurbakh Singh Sibia as well as in Deepak Mahajan that even if there is any apprehension, now they are saying that the apprehension is vague, that most probably, that we have filed this application just trying to avoid appearance and trying to evade arrest, if any, but saying that that the petitioner was not well at that point of time. But there is a genuine fact that the petitioner was ill. Proper documents have been annexed there. Medical documents were there at that point of time when he did not appear in the first time and he was represented by his legal practitioner. But later on, he appeared in compliance with the Honorable High Court's order. And then comes this particular fact that if they still has an apprehension that no, he will flee away, he's not going to come back, he stays in Jharkhand. This is a matter jurisdictional, this scope is in the Kamrup Metro since the enterprise in Assam. So these are now they're actually assuming, they're creating some sort of fictitious circumstances that may arise. But as far as the petitioner is concerned, he is totally abiding by the conditions. He has recorded and as part that, and since the Supreme Court in these particular cases have said that pre-arrest bail, along with the other judgments, that pre-arrest bail can be entertained in case of GST. Only the fact is that if it would have been in the gravity of offense as well as the amount, now amount is also less than 5 crore, 3.42. If they come out with a charge sheet, if the amount is more, that is a subject matter to be taken up during the trial stage. He's going to appear and he's going to totally comply with the conditions. So my submissions are to the fact that their contentions and their apprehensions that he will flee away, that he will evade arrest, and that at that point of time, this is an nascent stage, investigation going on, he could hamper with the evidence. No, it does not arise because already the case in which any hamper or tamper could have been done is already now before trial. In this Pritam Sobasaria case, and already amount is ascertained, charge sheeted. So where is the now requirement that he will go and he will hamper or temper? Because they specifically they've stated Nilima Enterprise and PS Enterprise in the objection. And as far as the petitioner is concerned, the matter is now before the trial court. So the fact that since it is charge sheeted matter in that particular case, now here, if it is charge sheeted, then he is going to face the trial as per the procedural law. This is my humble submissions.
My pleasure, Lordship. Taking the submission of my learned friend, he said that this is a non-bailable offense. Then in case of bailable offense, how this petition is maintainable? The Lordship knows that in case anticipatory bail is applicable only in case of non-bailable offense. Now, Lordship, I want to place one paragraph of Radhika Agarwal. Because Lordship, the petition has come before December Court with an application challenging section 17 notice. Let's say supply the copy. I'm reading slowly paragraph 69 of Radhika Agarwal's case. The copy is not with you.
Yes, it has.
Paragraph 69.
69. Yes.
Start from however.
Yeah, yes.
However, we may clarify that a person summoned under section 70 of GST Act is not per se an accused protected under section article 23 of the Constitution, as has been held in case of Deepak Mahajan Supra. This is because the prohibitive sweep of article 20 clause 3 of the Constitution does not go back to the stage of interrogation. Reference in this regard has been placed in judgment so and so. It is obvious that the investigation must be allowed to proceed in accordance with law, and there should not be any attempt to dictate the investigator And at the same time, there should not be any misuse of the power of the authority. So Lordship, notice and under section 17 is issued to him. And in our, I'll come with my objection also. Now Lordship takes paragraph 70. This is with regard to anticipatory bail. That is some restriction has been put. We also wish to clarify that the power of grant of anticipatory bail arises when there is an apprehension of arrest. The power vested in the court under the code affirms the right of liberty under Article 21 of the Constitution to protect the person from being arrested. Thus, in Gurbakh Singh versus Sibia versus Supra, this court has held that when a person complains of apprehension of arrest and approaches for an order of protection, such application, when based upon facts which are not vague and general allegation, should be considered by the court to evaluate the threat of apprehension and its gravity and seriousness. In appropriate cases, the application for anticipatory bail can be allowed, which may also be conditional, and it is not essential that the application for anticipatory bail should be moved only after FIR is filed, as long as facts are clear and there is reasonable basis of apprehending arrest. This principle was confirmed by the recent constitutional bench in 5 judges bench in court in this court in case of Sushil Agrawal and others. Some decision of Choramani Singh and so of this court in context of GST Act, which are contrary to the aforesaid ratio, should not be treated as binding. So Lordship, he can approach the court. Lordship, this is a general rule that anticipatory bail lies only in case of non-bailable offence. Yeah, now Lordship, now I am come to my objection, Lordship. Paragraph 4. This is nothing but a abuse of the process of the court only. Paragraph 4.1. Before addressing the specific amendments in the petition, it is imperative to place on record the finding of the preliminary investigation. Credible intelligence was developed by the Director General of GST, DGI Guwahati Zonal Unit, indicates potential large-scale fraudulent availment of input tax credit by the petitioner's proprietor concerned, MRN Minerals, under the provision of Central Goods and Service Tax Act 2017. The intelligence suggested that such ITC being availed based on invoices issued by certain non-existent and non-functional entities. Please note down this line, Lordship. Without any corresponding physical receipt of the goods. Without movement of the goods, they raise the bill and avail the ITC. The preliminary investigation, including analysis of the GST return and available data, revealed that the petitioner's firm had prima facie availed ineligible ITC amounting to rupees approximately 3.42 crores, which is below 5 crore, Lordship. This is a bailable offence, if it at all. So these are the Lordship. Now, Lordship, may come to page 50. Paragraph 10. In this, petition safeguard has been provided by the Act itself and subsequently by the Radhika Agrawal, in which case and how it arrest to be made. Lordship, that is a question of to be decided by the authority, Lordship. That with regard to the amendment made in paragraph 5 of the anticipatory bail application, the answering respondent further state that the petitioner's apprehension of arrest is wholly misplaced and appears to be contrary ground to evade joining of the investigation and answering petitioner's questions regarding the firm's operation and legitimacy of the ITC availed. The power of arrest under section 69 of the GST Act is not exercised arbitrarily or merely upon issuance of summons. It is invoked only when the proper officer, based on credible material gathered during the investigation, has reason to believe that a person has committed a cognizable and non-bailable offence specified under section 132 of the GST Act and concludes that such arrest is necessary for a specific reason like preventing further offences, tempering the evidences, influences of witnesses, or ensuring presence during the investigation trial. The petitioner's statement is crucial to determine if such conditions exist, his deliberate non-appearance hindrance this assessment and fail the suspicion that he might be information he is seeking to conceal. The cited medical ground appears to be convenient excuse rather than genuine inability to cooperate. My learned friend submitted that he appeared by the authority. When he appeared, when he got the interim protection petition, got only. Earlier, Lordship, he was avoiding, and he appeared through his learned counsel, Lordship. That is not permissible under Section 70 of the GST Act, Lordship. So, in my humble submission, Lordship, this petition is premature. There is no apprehension at all. So, this petition is liable to be dismissed. And we have in our objection, Lordship, we have dealt with all the agreements. And Lordship, one submission has been made that in subsequent paragraph we have that is reply to his application, Lordship. From paragraph 4, Lordship, this is our investigations report, Lordship. And subsequent paragraph the reply to the agreements made in the bail application only. So I am reiterating, Lordship, the petition is premature. There is no apprehension. And as in paragraph 16 of the Radhika Agrawal, Lordship, again I am reading. Last 2 lines. It is obvious that the investigation must be allowed to proceed in accordance with law, and there should not be any attempt to dictate the investigation. And at the same time, there should not be any misuse of power and authority. Under the circumstances, Lordship, this does not come. And my learned friend submitted that we have come to a figure of 3.4. This is a bailable offence, Lordship. In case of bailable offence, this petition is not maintainable, Lordship.
Lordship, if may I, a learned senior counsel has, since he has already stated, let me just reply regarding this. In his same objection, what I am trying to submit is that 3.42 crore is the amount that has been asserted at this stage. So during the course of investigation, it may increase. It may go on to become a non-bailable offence. Now, in para number 10, page number 50 of their objection, what they say, that with regard to the avertments made in paragraph 5 of the anticipatory bail application, the answering respondent further states that the petitioner's apprehension of arrest is wholly misplaced and appears to be contrived ground to evade joining the investigation and answering pertinent questions regarding the firm's operations and the legitimacy of the input tax credit avail. The power of arrest under Section 69 of the CGST Act is not exercised arbitrarily or merely upon issuance of summons. It is invoked only when the proper officer, based on credible material gathered during the investigation, has reasons to believe that the person has committed a cognizable and non-bailable offence specified under 132 of the CGST Act, and concludes that such arrest is necessary for specific reasons like preventing further offences, tampering with evidence, influencing witnesses, or ensuring presence during investigation trial. The petitioner's statement is crucial to determine if such conditions exist. His deliberate non-appearance hinders the assessment and fuels the suspicion that there might be information he seeks to conceal. The cited medical ground appears to be convenient excuse rather than a genuine inability to cooperate. So the fact is that the petitioner's statement is crucial. So he has already given the statement. And now the fact is that if they are saying that they are still ascertaining, and they will later on, if it comes to some amount which is more than that particular permissible limit, then he may go to, then they may take some actions. It can be assumed from here because the statement is crucial. He has already made his statement. So the fact is very simple, is that if any examination
So
is
you are saying that if in future it goes beyond 3.42
yes,
crores,
it may.
then how can, at this stage, how it can be possible to ascertain that it may go beyond 5
yes,
crores?
that is the reason. Now the fact is that since the investigation is going on,
Yes,
so
obviously.
since the investigation is going on, if required, if let them develop upon the case, if required, let them investigate. We do not have any problem onto that particular fact. If they want to develop and if they want to file a search sheet or anything of that sort, then they have the right to do so. Only fact is that our thing is that my interim should be, at least I should be protected till that point of time, till they have ascertained. If they have finally filed a search sheet, or if they say that it is available, then it extinguishes, my right extinguishes, and I'll appear before the trial court. That's it. So to that extent only. So whatever he's submitting is correct, but we do not know now at this stage, because ascertaining, that means it is not yet ascertained. It's still there. So that is my contention, my lord.
Okay, just for clarification, the GST is a self-assessment procedure. It is to the petitioner, they have to disclose everything.
So we are there to disclose,
So
my
that
lord.
don't disclose, that's why Lordship, the section 17 notice was issued, and 16 and paragraph 16 of the
Yes.
article is very clear. There should not be any hindrance in investigation.
Absolutely, totally.
And Lordship, when the amount has been below, then how the petition is maintainable, Lordship? This is my humble submission.
But here only they themselves they are saying that it is in a nascent stage of investigation and they are trying to figure it out. So if that is the thing, then let them develop the case. We do not have anything to say on that. Only fact is that my right under Article 21, it also goes to that particular right. It flows from 21 and it goes to regular bail as well as pre-arrest bail. Article 21, right to life, right to liberty. It is my fundamental right. So the fact is that since I have duly cooperated in compliance with the Honorable High Court's order, the very unfortunate fact is that they have not mentioned the Honorable High Court's order in their objection. That I have that the petitioner has complied in pursuance to. They have stated that Rajkumar Mishra has come and has recorded the statement under Section 70. But it is under the compliance of the Honorable High Court's order. There is a direction. So why they have not mentioned it is very unfortunate that Honorable High Court has been left behind. And they are more with Section 70 of the CGST Act, saying Section 70 is very important and you have to come and appear. But unfortunately, High Court's order is not only reflecting here. Because as per the order of the Honorable High Court, the petitioner has gone. Yes, it is a fact. He has to be given the protection. It is his right. So that is why Honorable Court has interfered and has given the right for interim protection. Now, if we say that this is not maintainable at all because his figure is 3.42, then they have to give a statement saying that 3.42 is the amount. This is the amount, and this is a bailable offense. Then at this point of time, this particular right goes extinguished. That is my humble submission.
Lordship, if this is submission of my learned friend, Lordship, I will produce the statement tomorrow, Lordship. What he has appeared and what he has stated before the authority. Yes, everything is concealed by him, Lordship. I'll put Lordship fix the matter tomorrow. I'll place the statement recorded after.
My lord, that is why I'm saying then again issue someone.
I'll place all the document, Lordship, to counter the statement of my learned friend. He is not cooperative, and he has evaded all the materials before from the authority, Lordship. And this is not a fit case for granting intercivity bail, Lordship. I'll produce, Lordship, all the statement tomorrow. Lordship may fix the matter tomorrow. Everything will be clear before what he has been stated before the authority when the protection was given to him. This is the Lordship. They are destroying the economy of the country, Lordship. And section paragraph 16 is very clear. Only notice has been issued. What apprehension is there? Even if it is there, Lordship, we have to comply with the necessary formalities of before arresting him, Lordship. Simply a right has been given to them, they cannot misuse, and that is also subject to some condition also.
That is what we are seeking, my lord. I'm totally agreeing with my learned senior counsel, and he has really said it in the absolute appropriate manner. And I'm only saying that give us conditions, strict conditions. Just give us strict conditions. Finish. All conditions we will, if we do not comply with the conditions, vacate it. Finish.
That is not the question.
No, that is the question, my lord.
Investigation is going on. Whether he is entitled to at all intercivity bail at this stage in view of the radical.
So then let us keep this matter pending, my lordship, and then
I'll place all the materials before tomorrow, Lord. I'll place the case diary and the statement recorded by him. I'll point out, Lordship. We have
Tomorrow, same position. Tomorrow, I don't think so. So,
my lord,
if your submission, I have recorded that he is not cooperating.
Yes.
Or he is not disclosing all the facts and these things are there. So that may be corporate. Otherwise, we have to give a date.
No, Lordship, I'm just replying to the statement of the learned friend that we have not mentioned about the High Court's order and he is entitled to bail.
That is bringing
from all the documents, I'll prove that what is the conduct of the petition.
Absolutely, he has got the right and he can do so.
If you want to place all the documents or the statement, then may not be possible tomorrow or this week is not possible. That is why otherwise I'll pass the order.
Keep the matter, Lordship, for CAB. In the meantime, I'll submit court's case diary tomorrow, Lordship.
No, in that case, he will be there, no? That's why. He has to be.
He's not entitled to.
No, not the case diary, but if you're going to place the statement.
No, I'll place the case diary before our Lordship, for perusal of Lordship. Because he has made a statement, he has stated that he is appeared before the authority.
Yes, yes.
He knows what his statement he has made. Just to counter his
so to issue again as someone, call him again.
That is different thing. Lordship, whether paragraph 16 has given any individual inflexible right to the petitioner, not to cooperate with the investigation.
Obviously not.
Yes, Lordship, all these things are there.
So you keep it pending for this order or?
No,
you want
Lordship
to-
may,
Pass the order, you may
I-
place the
yes,
his
place the
statement
case.
tomorrow.
Yes, Lord.
In that case, Mehdi, you want to submit anything?
No, I said, my.
No, he is only going to, we are not going to hear the matter. Now you are saying that you have already cooperated, appeared and
Yes,
everything
yes,
is there.
yes.
In the earlier occasion, you could not appear
Yes,
due to
yes.
your ill health and through counsel.
Correct.
You appeared, but that was not admitted or it is not, I mean, as per law, it is not
Yes,
admitted.
yes.
So that is there and otherwise you have appeared and cooperated
Yes,
in the
yes, yes,
investigation.
yes.
He is saying that in the name of cooperation, you are not cooperating rather.
Yes.
Yeah,
If that
his
is the
main
case,
concern.
then it is very, I do not have, I do not know, but whatever facts and figures I know, I just know that
Yes,
he
obviously.
has appeared and he has stated that he has
No,
cooperated. If
appearance
he
we
has
are not
not, then
disputing.
definitely.
Appearance we are not disputing.
Yes,
He is
yes,
appear.
yes, so-
We have stated.
And in the
objection.
objection itself, they have stated that he has recorded his statement. So in the objection, they have stated. Only fact is that they have stated here that in 4.8, my lord, 45. 4.8, 45 is statement of Sri Rajkumar Mishra was recorded on 7/4/2025 and 9/4/2025. That means on 2 days he has cooperated. Actually, 3 days now. The first day he has not cooperated, but on his behalf, one legal practitioner has gone, legal representative, and submitted the documents. Actually, he has gone to submit the documents since he has not able to come down. So 3 times he has cooperated, 3 times. That is on 7/3/2025, then on 7/4/2025, and on 9/4/2025. So 2 days they have got ample time. Now, if he is not cooperating during that point of time, then I have some little reservation on that. I don't, maybe he could be in the best position to put the facts across the table. Only fact is that here, what the statement says that Messrs. MRN Metals and Minerals is engaged in trading of ferrous scrap items. He resides in Jamshedpur and mostly conducts business over phone. On being shown the Panchnama drawn at principal place of business of Messrs. PS Enterprise, that is that particular enterprise which is now.
Oh, okay.
Yes. So going through this particular objection which they have only filed, it can be stated that he has been cooperating because these are statements which he is giving. Only fact is that if some other than these statements they want some more information, then it is his prerogative now. He has to cooperate. And if learned senior counsel, if he is able to show that yes, he's really not cooperating, then maybe it will be upon the honorable court. Now things are left before the honorable court because the fact that as per the law says that pre-arrest bail is applicable in case of these GST cases, which now falls in the economic offenses, since these are financial irregularities. But the fact is that how much of effect it has gone to the society is also have to take into account. Now the fact is that he has paid amount. He has paid here in the objection. They have stated that he has paid 18.3 crore to this particular person, this PS Enterprise, that is run by this Pritam Sobhasria. Now and they have unhearted that some 15 point some crore has been paid. So he has paid.
One can be
I'll submit to the court master law.
submit to the court. Master. Oh. It's forward chamber. I'll put your submission to some extent and you submit. I'll just peruse the statement, that much. Okay.
I'll put up all these relevant paragraphs.
Pardon?
I'll put up the flag marks. On the
Yes, in the CDU flag marks you were doing if there is any non-cooperation. List knock around it will order of an লিখব লাগে না ডেলিভারি অর্ডার কৰি থক লাগিলে tomorrow for delivery of order কৰি দিয়ক day after tomorrow it cannot be or maybe day after tomorrow is a holiday I think let it be on 8 then 8 কৰি থৈ দিয়ক for delivery of order he is only going to submit that one no more here
the court master lordship
okay
much
obliged.
My lord, sorry, my lord. Item 46, my lord.
No, it won't be hard now. It won't be here now.
Concerned person is there, my lord.
No, we are not going to hear this.
Finally, tomorrow, my lord. They're in jail, my lord.
No, sorry. After 1 week, I have already listed. We have lots of matter. We cannot.
Yes.
Yes, 37.
Yeah.
37, you were there?
Lordship.
Yes.
So matter, my lord, CD not received.
CD not received. And otherwise you are appearing. They have to require, the CD is required then.
It is required.
You are not on interim, I think.
No. Earlier rejected, my lord.
Earlier rejected. Oh. Heard Mr. A.M. Rahman, the learned counsel for the petition, also heard Mr. Adar Kochi, the learned additional PP, and Mr.
Not, sorry, I'm sorry, my lord.
I
Not
mean,
rejected.
huh?
Not rejected.
Oh, I mean, the learned. You are appearing for informant. Informant as per numbers. I mean, your name is not reflected to that.
Today
Received. I mean has received appearability, so and so. It is submitted by Mr. Koshi, the CD not received. Full stop, issue reminder, when it can be listed, Koshi?
Any date? Because I think
we don't have.
table 20, there is no date.
Possibility is very less.
Yes, my lord.
Fixing a date.
14.
We don't have.
Both fixes.
20th, 20.
20 at best. It's anticipatory only. 20 can be. Yes, 20, and in the meantime, Mr. Amin, the respondent number 2 is at liberty to file their objection, if any. Okay.
Item 38.
May I please, your lordship?
30th also, my lord, CD not received.
There is no protection for me, my lord. The allegation is of 21B and 29(1) of NDPS Act.
Now see, in NDPS, we cannot give any interim protection. We don't have any alternative. So that is
There is
easy
no
because
recovery
you may
made
be,
from me, my lord. No contraband found on my possession.
but you
my
may
lord.
be a peddler, no?
And there is one co-accused, my lord, already granted
You
bail.
may be a peddler, that's what.
My lord, I am a fruit vendor, my lord, not peddler, my lord.
How can we say now at this stage? Because 29 is there. 29 is there. If 29 would have been not there, then the matter would have been different because you may not be, recovery may not be there, but 29 is there.
Merely on the basis of the statement of the co-accused, the main accused.
Now see,
And-
this is not your regular bill, but anticipatory. That is
Anticipatory,
the difference. Why CD is not here?
This is the first occasion actually it has been called.
3 accused, my lord, 1 already granted bail, your lordship. That's why I'm pressing, my lord. If some
that
bail
is,
protection is granted,
One is already granted by
the sessions court, my lord. If your lordship will.
same under the same footing.
Yes, ma'am.
Without perusal of the CD or on
After
perusal?
perusal of the
After
CD.
perusal.
That is regular bill, my lord, not anticipatory.
Oh, that is regular bill. That is regular bill, not anticipatory.
If I may read, my lord, on the.
No, that is not the regular anticipatory. That is
That is not
regular
the
bill.
anticipatory, my lord. Fine,
In,
my lord.
in their year case also, if some considering your period, suppose there may be a ground for bail, but the question is that we have to peruse the case diary because it's an NDPS matter. I cannot give any interim here.
On 20.
20. 20 will do. 20. Issue reminder 20.
Obliged, my lord.
Okay.
Time being matter. Item 45.
Item
45.
Yes.
Lordship, today is the 143 days. my lord.
Huh?
Today is the 143 days.
Huh.
FIR page 13.
That here,
My
CD
lord-
receive without FSA, this is a commercial quantity.
Yes.
Commercial
My lord,
quantity.
so many dates have been passed for FSL. Our case is that it is, weight has been made with strip. That is my lord, page 30.
No, whatever your case is of commercial, isn't it?
Registered commercial, but our case is that my lord, only 575 numbers of capsule from 2 accused persons have been recovered. In the meantime, my lord, I have also.
So that I don't know, but 29 is there. So
29
when
FSL
29 is there, then how can we say?
But
But obviously he's rightly submitted that case is pending since long, but
so many 5
because-
Otherwise, this is a commercial quantity, 180 days is the mandatory period. my
no,
lord.
that is there, but
That is there.
in spite of that, you are calling for the
140
case
days.
diary.
But CD is here.
Huh?
One
CD is here.
CD is there, FSL is not there.
FSR, my
Your,
lord,
your, how many days you are in custody?
143 days. Even I have, my lord, I have also taken the ground, my lord, page 15. Only, my lord, that is the forwarding report, page 16. Only reasons of arrest. There is no ground of arrest.
No, no, other, 47, 40. do you have it?
47 also not complied. My lord, I have filed additional evidence annexing the, my lord, page 24. This is notice, only reference of case number is given, nothing in page 24 of
Page
my,
24.
of my additional evidence. Only case reference number is given. Then, my lord, page 25 also.
Your petitioner's name is Minnas.
Minnas, my lord.
Yes.
Only reference, nothing, my lord, no ground. Even, my lord, forwarding is also no ground. Notice is also no ground. Arrest memo is no ground. Page 25 is the arrest memo.
No, but this is not the certified copy.
I
have
am
you?
having the original, my lord.
Yes.
Yes, my lord, in item today's, my lord, relevant order in item 43 and 54. Also, my lord. Same case.
Out of same affair.
No, my lord, not. My lord also decided early delivered order on the ground. Even nowhere, my lord, ground. Even 47, no 48, and even arrest memo, no ground. Even forwarding report also before the magistrate. Only the page, that is, my lord, page 16 of my petition. Only reasons. Yes, my lord, might not know very well the difference between the reason of arrest and ground of arrest. Nowhere ground of arrest.
He's posting, otherwise he has a case, I think.
I am also submitting my lord's one order. For my lord. That order, and my lord already dealt with.
Okay. ये preliminary लिखी लेबो तेखেত হৈছে hard Mr. M.R. Khandekar. How many days you are in custody?
143.
140 days in custody. Not yet charge sheeted. Episode of ground of arrest is. Rana Koshik of Divo admission. Commercial quantity, you go 37. And that part FSL is still awaited. CD receipts, FSL is awaited. Ground of.
My
Okay, then.
objection may be recorded.
Yes, your objection may.
I am deeply.
Is this cases of which district?
Oh, my lord, the special judge, South Salmara.
Special judge, South Salmara.
South Salmara, Mankar.
Okay. Okay.
South Salmara, Mankasar.
Yes, South Salmara,
Mankasar. I am deep.
Daily list for orders, item 39.
May I please, Lordship? Lordship, this may be tagged with read petition number, read petition criminal number 3/2024. On the same issue, there is another read petition pending.
Read petition, yes, number. Read
Read petition
criminal
criminal number 3/2024.
3/2024.
Yes, Lordship.
And rest apart, have you taken any steps or is there any issues of notice order and all?
Lordship, on the last occasion, because
Yes.
there is one respondent, on the last occasion, the advocates counsel, counsel for the respondent has appeared. There is the order of your
Yes,
Lordship.
one appeared. And Mahanta Dilanded counsel for the correspondent number 3, one appeared. Someone appeared.
Yes, Lordship. He is the sole respondent.
Why it is listed as respondent number 3, in fact?
Probably, Lordship, in the other page, cause title page, the accused number 3. Oh, sorry, Lordship. No, there is only one respondent, that is Otulo Limited. Probably, Lordship, what has happened in read petition number criminal 3/2024, the Otulo Limited is the respondent number 3 because their states are also made parties.
Oh.
That is why this mismatch has happened.
Acha.
and it is relating to the same issue.
So
It is-
here you have only a sole respondent.
Yes, Lordship.
Who is he?
Otuloto Limited, represented by Yogaraj.
Auto Limited. Acha. 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 Oh, sole respondent is there only.
Yes, Lordship. Because states were not made party. In the other one, which states are also made party, the state of Assam and state of Gujarat were also.
Why state of Assam is not made party here?
Lordship, initially when we filed this writ petition, this is against the check bounce case.
Uh-huh.
I was under the impression that as because this is a case of private nature, so I didn't make the parties. But subsequently, I made in the other writ petition, I have made the party. The state of Gujarat and state of Assam were made parties as because the notice will have to go if something has to be replied by the court. Then in Gujarat, then it will come to the Assam. So states were made parties later.
In the other matter.
Yes, Lordship. This
So
check bounce
we have
case-
simply tag with this one.
Yes,
Other
Lordship.
one.
Yes. The issue is same.
Heard Mr. S. Tamil, the Honorable Counsel for the petition. None appears for the respondent. Though, on the earlier occasion, Mr. A. Somo appeared on behalf of Y and Mahanta for the respondent. Further, Mr. Tamil submitted that the present writ petition criminal may be tagged with the writ petition criminal 3/2024. Mr. BST is accordingly directed to do the needful in this regard. BST matter accordingly. After 2 weeks, we'll do. Just after 2 weeks. So this petition is basically in the case check
Check bounce
bounce.
case. The one check bounce, the part of the transaction took place in Assam. So, and the petitioner here is one of the silent director of the company. She has been made an accused. So she has filed this petition.
Okay. Okay.
Main managing director has already expired.
Expired.
In the main case, the other one.
But if it is a company, then in that case, to
Legal representative, but that managing directors are having 4 wives. So there is dispute going on between them.
So she is also one of the wives.
Yes, Lordship. But
Oh.
officially she cannot be said to be a wife because the first wife during the having subsistence of marriage with the first wife, he made 3 more. Ultimately committed suicide.
He is a Muslim person.
No. He is a
Hindu.
Hindu.
Acha,
His name was Kumar Gaurav Singh and he has ultimately committed suicide.
Oh, unfortunate.